to a hearing in relation to a planning obligation appeal under section 75A of the Town and Country Planning Scotland Act 1997. My name is Paul Paquette. I'm a DP reporter appointed to determine the appeal in relation to a 60-unit site at Deanburn Road in Lithgow, for which planning permission was granted on 24th March 2022. This appeal follows the non-determination of the planning appeal application, and the appeal was taken on the 2nd of February 2023. I'll ask parties to introduce themselves just in a moment, but I just want to make a few preliminary comments in relation to the hearing that's set for today and for tomorrow. The first of which is to just confirm what I think we've written to parties before, is that the participation of parties in this hearing session online is taken to be with consent in terms of GDPR and other data protection purposes. The recording of this is available live for those who are interested in watching live, but it'll also be available on the DPA website for consultation later on by parties if they so wish. All the documents that are being referred to in the course of this hearing, but also in the course of the appeal generally, can be accessed by parties and anybody with an interest by accessing the DPA website and by searching under the case reference, which is POA-400-2010. This hearing will proceed under the hearing session rules in terms of the Town and Country Planning Scotland Appeals Regulations 2013. As I mentioned in previous correspondence, I've been to the site and seen it from off-site. Obviously, I've not gone on the site on 2 occasions earlier in the summer. Under previous correspondence, I'd asked whether any party considers that I should carry out either a further unaccompanied site visit or an accompanied site visit for the purpose of this appeal. No one has indicated any suggestion to that effect. And obviously, if anybody does wish me to do so, please say, but I'm working on the basis that there'll be no particular need for a further or an accompanied site visit for the purposes of this appeal. An agenda has been circulated, and I'll say a little bit about that in a minute in relation to, in particular, to the representations from the Lithgow Planning Forum. But otherwise, the agenda is the basis on which I'm intended to proceed for the hearing today and tomorrow. A number of documents have been lodged, as I say, accessible on the DPA website. There have been some of those were lodged late, just after the 2-week period for hearing statements, but none of those are objected to. One document lodged yesterday on behalf of the appellants that we'll come to in a moment, but the documents are otherwise as submitted to DPA. My intention today is to take a break for lunch at around 1 p.m. for an hour, if that works for parties, but conscious that this is still not a particularly natural form of communication. I'm intending around 11:30 or a convenient time around then to take about a 10-minute break, and I'll do the same sometime in the afternoon as well. However, having said that, if anybody at any point wishes to have a break for any reason, you just shout and we'll accommodate that as far as possible. And that will probably at around 11 o'clock include me, because my doorbell will ring and a parcel that should have been delivered yesterday is likely to require to be delivered. So if I rudely interrupt and dash downstairs, hopefully only for a short period, to get some more ink on my printer, please forgive me for that. The intention is to finish around 4 p.m. today, but that will be a bit dependent on how things go. We have a further day tomorrow. I mean, I've no real sense of the extent to which we'll need the full 2 days or maybe need more. We'll just have to see how that goes. But we do have the capacity, if parties, if this works for parties and they're keen to do so, and if it proves necessary, to do a 9 a.m. start tomorrow morning. But we'll play that one by ear as the day goes by and decide what the appropriate sense of a potential finishing time might well be at the end of tomorrow. But we can judge that as we go. I'd indicated to parties, and this will be of particular interest to the lawyers in the room, that in accordance with my normal practice for hearing sessions of this nature, I'm not going to be expecting closing submissions at the end of the hearing session to be presented at that point. My intention is to set a time limit possibly 7 days, maybe longer, depending on what's needed. We'll talk about that at the close of the hearing today or tomorrow. But as I say, to assure lawyers present that there's no expectation that they'll need to gather their thoughts for closing submissions at the end of this particular hearing. I'm going to introduce parties just now. Ask them to introduce them and their witnesses as needs be. Partly, I mean, this is true for all participants, partly for the planning forum in particular and Councillor Pattle. I'm going to give an opportunity to parties if they want to make a brief comment, if there's anything they want to say at a general level before we get into the detail of what we're here to address. Then I'll do that after the introductions. But I'd be keen, nevertheless, for any opening statements, effectively, any opening comments you feel I need to be aware of, or any issues that anybody wants to raise at this stage. To give you that opportunity to do that just now. And I should emphasise again to the lawyers in the room who are here with experts in various areas, please feel free to bring in whatever particular witness or expert has relevant knowledge and expertise on a particular topic. I'm grateful for the brief statements given by those who are attending as witnesses. It's really useful to me, particularly in a hearing context online like this, to be able to identify quickly and readily who questions should be addressed to. So that's been immensely helpful from my point of view. But if I go around starting with the appellants, if you could maybe just introduce yourself and your witnesses.
Good morning, sir. I suspect my screen tells you that I am Emma Hendry. I'm not. My name's Ewan MacLeod. I'm a solicitor with Shepherd and Wedderburn, and I'm representing the appellants today. I have one witness with me today, sitting on my left, who is Mr. Alex Snedden. Just one very brief point, picking up on your 11 AM issue, sir. I have an issue at 11 AM as well, because apparently there is a planned fire alarm for the building. So it would work quite well for me if we were able to take a break for perhaps 10 minutes at around 11 o'clock, just to avoid any disruption to the evidence at that point.
Yeah, I'm very happy to do that. I presume no one else would take any issue with that. I can't be certain when my parcel will arrive. It would be fantastic if it did around that time, but well, we can certainly happy to take that break at 11 AM, either if we remember to do so or if your alarm goes off in the background, so we can certainly do that. Excuse me. I have only one question in relation to Mr. Snedden. We're sitting on your left, Mr. MacLeod. I noticed that he is a director of Transport Planning Limited. And I was also aware, and is appearing obviously for the appellants to assist this morning. I'm also aware, though, that the transportation report that was produced by CALA in relation to this appeal, original application, was also from Transport Planning, and I'm assuming that that's the same firm. It'd be useful if you just clarify whether the report was produced by Mr. Snedden or was produced by someone else within his firm on behalf of CALA.
I'll let Mr. Snedden answer that one.
Yeah, that's broadly correct. What you said there, nearly called you Paul there. But, but yeah, as I recall, I mean, the report's quite dated now, but I have a long history of living in and around Linlithgow, so I think it was a joint effort between myself and one of my members of staff.
Yeah. I saw the address of the firm with Linlithgow address, so I suspected there was some local knowledge involved in that. But just for clarity from my own point of view, bearing in mind that you're appearing on behalf of the appellant, that the report was prepared on behalf of CALA, just so that other parties are fully aware that I'm clear about that distinction for the purpose of today's hearing. So I'm grateful for that. Okay, now moving to Mr. Alexander of Morton Fraser on behalf of the council.
Good morning, sir. Yes, Rory Alexander, solicitor with Morton.
There's two Alexanders here, aren't there? So we may do what Mr. Snedden's just said and have to revert to first names.
Well, I'm perfectly happy with that. I have alongside me Vary Foy, as well as solicitor with Morton Fraser. In terms of today, Vary is going to take us through section 1, which is the preliminary issues, and I'll cover the rest of the issues raised in the agenda. We have a number of witnesses with us today, as well as you'll have seen from our recognitions. We've got Craig McCorriston, the Head of Planning for West Lothian Council, Steve Lovell, Principal Planning Officer for the Council, Stephen McLaren, Planning Officer for the Council, Brian Carmichael, Environmental Health Officer at the Council, Victoria Mungle, who's a Development Management and Transport Planning Manager, and hopefully Chris Nichol. I'm looking at him across the room. I'm hoping he's there or thereabouts to join us, and Chris is a Transport Planning Engineer. And I think that is us.
Okay, thank you. And now to Ewan Alexander of Princeton Masons on behalf of CALA. I think you're principally interested in section 1 of the questions proposed, but you can explain yourself.
Sure, yeah, thanks, Mr. Coquette. Ewan Alexander from Princeton Masons, representing CALA, and as you say, I'm here to speak to the extent required the points in section 1. I don't have any witnesses or other people accompanying me today. Thank you.
Sure, that's useful. And again, for the benefit of others, CALA are an interested party, which is a term for the purposes of the 2013 regulations, and are not the appellant, who are represented by Mr. McLeod. Okay, right, thank you for that. I now want to go on to Dr. Kelly, John Kelly, who I think is appearing on behalf of the Lithgow Planning Forum. I'm not sure if he's also appearing on behalf of the Civic Trust, but I wonder if you can maybe just introduce yourself, Dr. Kelly.
Thank you. Yes, I'm John Kelly. I'm the Secretary of Linlithgow Planning Forum, which is a subgroup of the Linlithgow and Linlithgow Bridge Community Council. But as a subgroup, it also subsumes a number of other groups, of which the Civic Trust and the Community Development Trust are but two. So I apologise if there's been any confusion between the correspondence which came from the chair, and the chair is currently from the Civic Trust. Everybody is a member of the Planning Forum. So that, yes, and I speak on their behalf.
No, that's fine. No need to apologise. I can understand there are different sort of diverse interests that are represented in what you're saying, and that's absolutely fine. And that's very helpful. In relation to your contributions, Dr. Kelly, what I'm intending to do, I've seen the submission. It was made on 30th August. What I'll be intending to do as we go through the agenda is basically look to the principal parties in leading their evidence and giving their submissions and representations to me. CALA, in certain respects, may well be brought in at the appropriate time as well. My intention is not necessarily to turn to you on every single point. I noticed on the submissions that you put in, there's a number of things you have no comment on. I'd like to bring you in on some particular aspects of things. I'll give you a chance in a moment to say something by way of a kind of introductory statement. But the fact that I don't automatically come to you and ask you questions shouldn't inhibit you from participating and making any points that you think fit. So if there's anything you want to chip in at any particular point, then please feel free to do so, either just by shouting or putting your hand up on the Zoom call, and I'll bring you in. It's not intended to exclude you from any participation in all of this. It's just that obviously the forum and the trust and the community council have, to a certain extent, a bit of a kind of limited interest in certain parts of things. But if you do want to come in at any point, then feel free to be doing so. And the second thing, I just while I have your attention here, is, as I say, as I wrote out last week, I was grateful for the hearing statement and the substance of what you were saying. It is, however, not my intention in terms of the agenda today to bring in the wider discussion about some of the issues that have been raised and are of interest and concern to the forum regarding another potential eastern bypass around Lithgow. I'm sure the council are probably aware already of your views and all of that. What you say there will hopefully be of interest to them in terms of their longer term approach to matters around planning in the town. But in terms of the appeal matters before me and the remit and scope of what I can do, and in terms of notice, principally to the appellants, of the issues arising there, I wasn't intending to add those particular issues to the agenda. But that's not to stop you making points more generally about the circumstances of the town, and those points you've made in your representation beyond that, I'll certainly have full regard to. But I just wanted to make that clear just really from the start. And also we have Councillor Sally Battle, who I think is the local councillor for the Deanburn Road area, and I maybe ask her to introduce herself as well, and I'll say something also about her participation too. But if Sally wants to just join the call just now. We're going to see Chris Nichols joined us, which is excellent. I'm showing Sally's still on mute just now. Oh, that's better.
Hello, hi there. I'm just supposed to be observing today. I haven't actually prepared anything.
Oh, no, not okay. Well, that's that case. If you're happy simply being an observer, then we're happy to have you on the call.
Sorry, I'm at my work, so I'm having to.
Okay, right, would you? Well,
I'm just kind of dropping in and out when I can.
Okay, that's all fine. What I was going to say actually is I'm conscious, and it's always good and welcome to have local representatives with their interest in the particular issues today. But I was conscious that you very probably wouldn't want to be spending 2 days listening in, and you may therefore have a limited ability to participate to that extent. But I was going to say to you, if you do want to join and rejoin at any point, and there's points you want to make, then again feel free to do so. I don't know if you wanted to say anything particular before we start, just generally if you're in your interest as local councillor, or whether you're just happy to observe in and about your other business.
Yeah, I think I'm happy to observe. That's what I said initially, that's what I was joining to do, was to observe the proceedings, because I think, I was only elected last year. I know my personal feelings on the development, but I don't really want to get involved at a councillor capacity at this stage. But I will, like I say, I'm at work. I run a bookshop in Linlithgow, so I'm sort of dodging in and out when I can. This is on in my office in between customers coming in. But if I do hear something and I think, oh well, maybe I should contribute to that, then I'll let you know, if that's okay.
Just say, yeah. Just put your hand up on the Zoom or just interrupt, and we can bring you in. So very, very grateful for that. Okay, that's all fine. Thank you for that. As I say, it was mainly around Councillor Patel. I was going to give parties an opportunity if they wish to just say anything by way of a kind of brief opening statement, or indeed if there's any other issues that they want to raise at this stage. But nobody should feel obliged to. We can just go into the agenda if that's preferred. As I say, my thought of kind of giving that opening opportunity was really around the local councillor. But I don't know, Mr. MacLeod, is there anything you want to say before, or should we just head into the agenda?
I'm quite happy to proceed just onto the agenda, sir. I think the only issue that you mentioned earlier on was the late document that was submitted yesterday, and I don't know whether you want me just to mention that at this stage.
I was going to mention that as we get to item 1, because item 1 was where I was going to ask you for clarification as to the current ownership position anyway, so I'll maybe come to that at that point. Rory Alexander next.
I'm equally happy to proceed with the agenda. Hopefully the hearing statements were helpful to you, and we can proceed in that manner.
Okay, thank you. And you, Alexander?
Yeah, same for me, thank you.
Same. And Dr. Kenley, is there anything you wanted to say by way of general introduction more than you've said already?
Just to say that our primary interest is in relieving the congestion in the high street, which is made worse by every single new development that occurs. So we're interested in the principle of using Section 75 to do that. Our concern is that we seem to be wrapped up in a single solution when there's hundreds of solutions to that problem. That's all I wanted to say. Thank you.
Thank you. Okay, right. Moving on in that case to the agenda, and I'm grateful for the hearing statements that were provided. I think somebody had worked out there are 26 different questions that I'd posed. In that sense, I'm quite happy that nobody has thought of additional ones to pose. So we have, I think, agreed the agenda to proceed thus far. So starting with section 1, which I described as preliminary issues. And the first of those is the question of the meaning of owner from time to time, and this is something where obviously the Section 75 agreement has various provisions in relation to the meaning of owner and the consequences of that. I was first of all just going to double check what the current ownership position is, but then as we found out from the hearing statement on behalf of the appellants, but then with the plan produced yesterday, there's been a development, and thank you to Mr. MacLeod for the title deed that was produced as signed. I don't know, you can maybe tell us, Mr. MacLeod, what the status of that is. I'll come to that maybe in a bit more detail in a moment in terms of registration status, but another document. So the situation, as certainly as I had understood it until yesterday, is the 60 sites where partly, by my calculation, I'd counted 22. You can correct me if I've got this wrong. Roughly an area of 22 units that were still on the land that were shown on the blue conveyance from April of last year that are retained by the appellants. And then there was the land that was transferred in April of last year, amounting, and again, you can correct me, to 38 units. But it would appear now, as of April of this year, that there's been a transfer of all of the remaining land, bar one plot. Plot 54, I think, was the land that's now the only land that's now in the ownership of the appellants. But I wonder if maybe Mr. MacLeod can update us just on the current title position to make sure I've now understood it correctly.
Yes, sir. Firstly, my apologies that this came so late in the day. Mr. Alexander, that is you and Alexander, and I have discussed section 1, and what we'd agreed was that, generally speaking, he'll probably address most of the title issues because his firm was more involved in section 75 than we were. But your broad understanding is correct, sir. Subsequent to the exchange that we had on title in early April this year, there was one final disposition, or one further disposition, which leaves us in a position where there is one plot that is owned by my clients, the appellants, and the remainder of the site that's shown on the disposition is owned by CALA. I don't know whether Mr. Alexander is able to give an indication of registration status, but I'll maybe hand over to him at this stage unless you have any other questions for me.
Yeah, I'm going to follow up with a couple of questions. I'd like to hear from Mr. Ewan Alexander in a moment, but a couple of questions really just from the point particularly of the appellant. I mean, the reason it came as something of a surprise to me yesterday, and I know it was alluded to when the hearing statements were produced, but the plan wasn't, so I saw it only yesterday, is that I've always been conscious of the possibility, and indeed it was part of the discussions between myself and your firm, Mr. MacLeod, in relation to the sisting, the period of sisting earlier in the year, and that we wrote, DP wrote out on the 4th of August. It's perhaps worth just refreshing my memory as I did yesterday. On the 4th of August, I wrote out through my case officer, saying that the reporters are aware that a partial land transfer to CALA was made on 23rd of April 2022. It is important that we're kept informed and aware of all future land transfer transactions, such as further disposals to CALA, whether registered or not, or any other change of circumstances as affecting the title position, as set out in the title sheet previously submitted to DPA in this regard. The title sheet, as you'll recall, was one that was submitted in February this year, which was before the April transfer, and it set out the title sheet position. at 23rd of June 2022. And so, two questions, one of which is why it took so long to tell us, to tell me about the further transaction. But actually, arguably more importantly, when we were having a discussion about the cyst, which I did cyst and now recall the cyst leading to the hearing today, it was indicated on behalf of the appellants that on the question of whether there's a prejudice, that cysting the appeal would be prejudicial because it would impact on the ability to sell the land covered by the planning obligation in line with the contract that your clients had with CALA. And I very much took the impression from that that the only relevant transfer at that stage had been the transfer of the 38 houses, and certainly was making decisions on the basis of that. Clearly, as it turns out, misapprehension of the factual circumstances as had been advised to me, and I was slightly taken aback to hear the transfer was as long ago as April, which was before any of this correspondence around the cyst arose. And it was suggested that the reason not to cyst would be that the transfer of the land would be prejudiced and would be inhibited because your clients may not get the price that they would otherwise be looking for the land when it came to be transferred. But we now know, of course, that transfer had happened some 2 or 3 months prior to those representations made to me. So I don't know whether you have anything to say about those two aspects before I come to Mr. Ewan Alexander.
Excuse me. I think that the only things that I can say, sir, is that firstly, it was an oversight not to provide details of that second disposition. Secondly, that I again apologise for that oversight. And thirdly, that I don't think it makes any material difference to the issues that were discussed at the time of either the cyst or the general submission that we've made as to your duties in relation to determination of this appeal. There is a parcel of land which remains in the ownership of my clients. The contract that my clients have with CALA, as I understand it, is that parcel will not transfer until at least the determination of this appeal. And the obligation that we are seeking to have removed from the Section 75 agreement remains binding on my clients, and therefore the appeal remains valid and something that requires to be considered and determined. Again, my apologies for the oversight, sir. It came as something of use to me personally, and I am sorry that it has come up so late in the day.
Okay, thank you for that. Thank you in particular on the assurance in relation to the agreement that you have, the clients have with CALA in relation to the non-transfer of that land until the determination of the appeal. That certainly, what I had decided before is because there was a retained land that gave jurisdiction and the obligation could be enforced against your clients, and therefore there was no issue of jurisdiction. And if it's the case and remains the position that you through the appeal, that will still be the position that there is a land ownership which gives jurisdiction for the purpose of appeal. That's a helpful assurance and reassurance from that perspective. So I'm grateful for that. But I'll move on to Mr. Ewan Alexander. But before I ask him to comment on that, again, I would remind him of his client's indication to me on the 3rd of May, which was after the conveyance concerned, when it was indicated that CALA does have an interest in, quote, some of the land. Now, some of the land, it turns out, is 59 out of 60 units. So again, perhaps Mr. Ewan Alexander will not be surprised that I was slightly taken aback to be informed about this particular development. But I don't know if he can say anything about that or anything more generally about CALA's position in relation to this, the information provided yesterday.
I guess in relation to the question that I think was touched on before Mr. MacLeod spoke, the position is that disposition has been submitted. The second disposition has been submitted to the Land Register for registration, and that process is ongoing. In terms of the second question about Cal having interest in some of the land, yeah, I take the point. I think on Cal's behalf that could perhaps have been expressed more clearly. So my apologies for any misdirection. I'm sure it was inadvertent, but I do take your point. So apologies for that.
Okay, thank you. It's useful to know that the title deed, I know that the 2022 title deed, when I was last told, had been submitted for registration, was going through checks by the keeper. Whether that's the case for the 2023 deed or not, I think it sounds as if it's still with the keeper. But again, I suppose from my point of view, just what I'm taking from what you're saying is that the intention that the personal right, effectively, and that disposition not yet recorded as a real right continues to represent the appellant's intentions and Cala's intentions. They will complete title on that basis. And it's subject only to necessary processes by the keeper, and that the transfer of plot 54, the last plot, will happen in due course, in accordance with what Shepherd and Wedderburn have explained to me in earlier correspondence, are the mutual intentions of the parties.
Yeah, that's correct. I don't know the answer as to whether or not the registration process in relation to the second disposition has been completed. That's something I can perhaps check at lunchtime and confirm. It is in the process. It's been submitted. It's been submitted,
yeah. I mean, it's as I say, the ways of the keeper can be a bit mysterious, and certainly what one deed is now a little bit, some considerable time after it was originally signed and submitted. So it'd be useful if possible to find that. But my main interest is just to make sure that that as yet unperfected title, nevertheless, that still reflects the continued intentions of both the appellants and Cala in terms of how they intend to progress matters, and thank you for your assurance from that perspective. I'll bring in Mr. Rory Alexander. I don't know if there's any thoughts you have as to the impact of this change of circumstances, either jurisdictionally or in other respects, in relation to this appeal.
Yeah, thank you. So, I mean, ultimately, from what we're being told and what we've been presented with, the appellant does have a land interest in the appeal site, albeit it's one unit according to the plan submitted. So I don't think there's an issue in terms of jurisdiction. We've obviously answered other questions within section 1 related to that, which we'll come to. But on the face of it, they do have a land interest within the agreement area, and the council, when the time would come to enforce, would enforce against them if they still remained a landowner for their one unit share of just short of £16,000.
Yeah. And Mr. MacLeod has said that the fact that it's one unit as opposed to 38 units makes no difference to the arguments before me, in terms of the kind of principle involved in the evidence and the information that we'll assess in the course of today and tomorrow. Is that a position the council accept?
Yes, for the reasons I've just outlined, that in terms of the agreement, they are an owner, albeit of a less area than we thought, but they are an owner.
Okay, thank you. That's helpful from that perspective. Okay, that's useful. And my only other question in relation to title position is just to reiterate, I think, which has been said in correspondence previously. I noted that there was Mr. MacLeod.
Thank you, sir. Hopefully that's lowered my hand now. It was just one very brief point in response to Mr. Alexander there. I'm grateful for his confirmation. It was just in relation to something he said about a £16,000 payment in relation to that, the one plot that is in the ownership or remains in the ownership of my clients. The payment would be the full amount, the traffic improvement contribution, because the way that Section 75 is structured is it's the full amount that gets paid at completion of the final unit, i.e. the one that is controlled by my client. So it's just to put that beyond any doubt.
Okay, Sandra.
I suppose we're getting to the detail of enforcement here, but I suspect that the council would review the agreement and enforce against the landowner. So at present, we have two from the papers exhibited, and they would seek to recover the proportionate share from each of the landowners depending on the extent to which they own, which goes back to my comment about what they would enforce against the landowner in terms of their current land ownership. But that would be obviously a matter when the time came. We're not at that stage just now, as I understand it.
I've got some questions in relation to item 1.5 of the agenda, which I think will touch on these issues of joint liability and how enforcement would ultimately is likely to progress at a later point. So we'll come back to that. So thank you, Mr. MacLeod, for just a reminder of that. Excuse me. The last issue in relation to item 1.1 is previous correspondence. We have had confirmation, I think, from the appellants that there is, or at least was, a stand of security over part of the subjects of the agreement land, but the position is that relates to matters not relevant to this appeal. That's certainly my understanding, based on the indications given by the appellant's agents previously. So, but there's a deed of conditions and there's a stand of security, but I'm working the basis that the security is relating to obviously a relationship between CALA and the appellants, but not relevant to this particular appeal. I think that's correct.
That's certainly my understanding, sir. Nothing has changed as a result. The only final thing in relation to this topic was just to give the document from yesterday a document number, which I think will be document A29.
A29, thank you. Okay. Item 1.2 in the agenda is the issue of the continued obligation of the previous owner following title transfer. And I think we hopefully address some of these issues reasonably quickly, because the responsibility of hearing statements have been quite useful. The issue of the continued obligations, I think, is clause 5 in the agreement. And I think parties are agreed in relation to clause 5. I'm trying to get up on screen just now. This question of no continuing liability, that indicates on the disapplication of section 75C of the 1997 Act, there's no continuing liability in relation to the agreement, and the owners will not be liable for any breach of the provisions occurring after the disposal of respective interest, save only in relation to liability of a subsisting breach prior to such disposal. How I've been reading that, and I'd welcome views of others if they take a different view, is that, well, we're now down only to one site, that since the obligation hasn't arisen as yet, at least bills haven't been, invoices haven't been submitted, and that land has now been transferred, at least to the extent of 59/60ths, over to CALA, then the liability of the appellants would effectively cease in terms of clause 5. There wouldn't be a continuing liability because there hasn't been any breach at a point prior to the transfer of land. Obviously, the transfer of land of the 60th unit is yet to happen, but on the basis of the understanding that's been given to me, certainly, that CALA have no intention of building on anybody else's land, that they will acquire the title of the last plot 54, before they build on that site, and that the transfer of title will then go to them. It certainly appeared to me, in terms of clause 5, that there would be no residual liability in terms of the appellants. Certainly, even as of now, in relation to the bulk of the site, but certainly in future in terms of clause 5. And I think that's what parties are saying to me. But I'll go first of all to Mr. MacLeod for his view in clause 5.
So I think what you've said is correct. Clause 5 would be helpful actually just to read clause 2.4 of part 3 of the schedule as well. So clause 2.4 says the owners undertake that the traffic improvements contribution shall be paid in full prior to the occupation of the final mainstream residential unit on the agreement area. And then there's an interest provision that's not really relevant, but the obligation is still there as things stand at the moment. I agree with you that so far as the 59/60ths of the site are concerned, the owner does not have liability for that land anymore, but the owner, my clients, still has liability to pay that transport traffic improvements contribution as per clause 2.4 of part 3 of the schedule.
Yeah. And if the situation is that land is transferred, as I understand is the intention, prior to the obligation arising or at around the time the obligation arises, that will also have the effect, presumably, of removing that liability from your client at that point. If that happens, and we're looking down to the future.
If that happens, that is correct. But as of now, and as at the point when you make a determination on this appeal, my clients will remain the owner and responsible for compliance with that clause.
Okay, I'll go to Mr. Ewan Alexander next on that, and then the council.
I can just to confirm agreement with Mr. MacLeod on that, all of he said.
Okay, and Rory Alexander.
I feel like I'm treading on Mrs. Foy's toes slightly, but I'll make
whoever's best placed to
so I'll perhaps pass you to her for now, if that's okay.
Yes, of course.
The council's position is liability is joint, and each owner is liable to the council only for the area of which they are proprietor, and that would relate to the occupied residential unit that the contribution became due in relation to.
Okay. On that basis, is it worth just looking at clause 4? This is an item 1.5 of the agenda, skipping on to this question of joint liability and the meaning of that clause. And I very much kind of welcome the views of parties just expanded. I know you've both given your views on the question of what joint liability means in relation to that particular clause. There's one issue that I think parties are all agreed on, is that the Section 75 land extends, I think, in total 9.9 hectares, but the Planning Commission site is only 6.2 hectares of that. And I think it's agreed that the balance of the land beyond the 6.2 hectares, which is the appeal site, issues of joint liability don't arise in relation to that part of the development that's the land that's not going to be subject to development. I think that's the case, although no doubt others can tell me if that's wrong. And I take that from the final words of clause 4, which I think refer, if I can just get it up on screen, I think refer to only such part of the development as may be undertaken as part of the agreement area. The development obviously is the planning development. I'll maybe start with that, and I'll start with Barry. Just on that issue of your views on the responsibility for the balance of the land.
Thank you, sir. For development out with the planning application area, it would be unlikely that the council would seek to recover payment in relation to that land if there was no development on it and the planning permission doesn't relate to it.
Yeah. So that indication of the council's intentions. Do you have any views as to what the interpretation of the clause means in that sense? Does it give you the power to do so?
It may give you the power to do so, but from a practical perspective, the council may not seek to do so, given the extent of development which would take place on the land, which, if there was no planning permission, would be expected to be nil.
Okay, thank you. Mr. MacLeod?
I don't really have a great deal to say on this beyond what's been put down. Mr. Ewan Alexander and I had a conversation yesterday, and we agreed that he would probably take the lead on matters of interpretation, given his firm's involvement in, in the Section 75.
Thank you. Alexander?
Yeah, I don't really have anything to add to what's been said in the submissions. I think that what you set out, sir, in what you said in the introduction is right in terms of what the respective obligations would be.
Okay, thank you. In relation to the appeal site, certainly the council's suggestion of the interpretation of clause 4 suggested there's a kind of pro rata assessment, and that the amount that's due would be kind of apportioned effectively if a situation were to arise at the point at which a payment was due, and if the land was owned by different persons at that time. The ability to recover sums would be dealt with on a kind of pro rata basis, depending on how much land is owned by those different parties. Obviously, within clause 4, there's some support for that proposition. I suppose my question, which ties into Mr. MacLeod's point, is that the clause nevertheless talks in terms of joint liability. I'm just interested in what would happen in practice if there were a split ownership position still when the obligation arises. I mean, there's a split ownership position just now, but the obligation hasn't arisen yet. We'll come to that in a moment. But my question, I guess, is whether the council's position is it's open to seek a kind of, if you like, to look separately, not severally, but separately at the respective owners and seeks recovery from them, or does there have to be an action or a demand for the payment jointly, and what does that actually mean? What would that look like?
I assume that you're addressing that question to the council.
Was it your first instance? Sorry, yes.
Yeah, the council would seek to enforce against the respective landowners.
Yeah.
So whichever party was the landowner at the time the obligation became due. And that would be in terms of the premise in the agreement that liability is joint.
But joint not in the sense, what does joint mean in that sense? I mean, I'm struggling a bit. I'll come to Mr. Alexander in a second. The reason I'm struggling with understanding what this clause means is I can understand the sort of the common sense logic of what you're saying, and I see the reference to different areas. But the reference in the clause is to joint, by which is meant not joint and several. And what it struck me looking at that is actually what's really meant is several, but not joint and several. In other words, separatable out based on the respective proportions of ownership. But the problem is that's not what the clause says. That's where I'm struggling a little bit to try to work out what it means. So I welcome yours and Mr. Alexander's views and just trying to get an understanding why the clause is drafted the way it is. When effectively the pro rata sharing out would tell me that's not joint liability, but separate liabilities. It does vary.
Is it?
Yeah, still with you, Vary.
Still with me. Can we take a second to confer, please?
Yeah, absolutely. Yeah.
Apologies for that, sir. So the council's position is on a plain interpretation of the clause and clause 4 joint liability is that it only relates to the development undertaken on that part of the agreement area, and that's set out in the last line of clause 4. And the reason for that, from the council's perspective, is if there is a multi-phase development, then the council doesn't wish to have issues with enforcement against separate developers. The intention is to enforce against the developer of a particular phase of the site.
So the intention then is not to take joint action if there was an issue, as in, if you like, one payment action. If it came to that against parties jointly, you would presumably be taking separate actions. But if that's
Correct.
the case, again, it goes back to my question as to why the clause refers to joint liability. So I'm trying to just get into what joint liability means. What you're effectively saying, it goes back to my point of whether it should actually be separate liabilities in respect of the separate different interests reflecting the ownership from time to time.
It should be separate liability in the sense that the council would seek to enforce against the party who developed the land and who was the owner at the time the contribution was due. And I suppose the purpose of the last line of clause 4 would be to clarify that.
Okay. Mr. McCorson had his hand up briefly, but it's down now. But I don't know if he wants to say anything in this respect.
Thank you, sir. Sir, I'd simply put my hand up to say that unfortunately I'm suffering from COVID at the moment.
Oh no!
So I'm not able to be with our legal representatives.
Are you okay to be here at all?
Absolutely,
okay?
Yeah, absolutely, sir. I'm feeling absolutely fine, but just self-isolating. So there may be occasions where communication between myself and our legal representatives won't be quite as slick as ordinarily we would hope. So there may be occasions where we do just have to take a little bit of time out, and apologies for that, but hopefully in the circumstances you'll understand that. But I don't have anything to add to the position which has been set out by our representatives. Thank you, sir.
Well, thank you, and hopefully you recover soon, and be one of the lucky ones with a mild version of it. So, but thank you for that clarification of the circumstances and some of those background issues. So I'll go on to you and Alexander now, because this, as I say, this is one of the issues that I think is important for me to understand just what that clause means, and it plays into the kind of relationship of CALA with all of this, albeit that you're not a party to the appeal.
Thank you. I mean, in terms of how any obligation would be enforced, that is a matter for the council. But in terms of how Mrs. Foy described the council's understanding of the interpretation of the clause, I agree with that.
Yeah. Okay. I wonder if Mr. McLeod wants to come in.
Yes, sir. Having said that, I wasn't going to get involved.
No, that's fine.
I've got one point to add, and it's a slightly different point, and it hopefully doesn't complicate things further. But it's back to part 3 of the schedule and the way that the traffic improvement contribution is dealt with in comparison to some of the other developer contributions. So if you have a copy of that, you'll see that 2.3 requires the full traffic improvement contribution to be paid prior to occupation of the final mainstream residential unit. That's 2.3 and 2.4. If you turn over the page, what you'll see is a variety of other contributions, not related to this appeal, but a cemeteries contribution, denominational secondary, non-dom secondary, play area, public art, etc. All of those contributions are to be dealt with in terms of clause 2.10 of that part of the schedule. And all of those are done on a per unit basis. So the traffic improvements contribution stands alone in the way that the Section 75 treats it. It's a lump sum payment rather than an individual payment based on individual phases of the development. And I just wanted to, I don't have any answers as to why it's that way, but I just wanted to put that out there so that it forms part of your consideration if you think it's relevant.
No, that is useful, and I'll maybe ask Barry to have an opportunity to comment on that. Obviously, that point about the inference, at least, that Mr. MacLeod is drawing from the fact that the recoverability of these sums is drafted differently, and whether I should draw anything from that in looking at the question of the overall liability.
Thank you, sir. The Council's position is that nothing should be taken from the particular trigger point for payment on the basis that this particular trigger point may have been later to allow the developer more time to gather funds to pay the contribution. That is the council's position. The later the trigger point, the more time the developer has to gather funds to pay the contribution, together with the council's general position that it would seek to enforce against the relevant developer.
Thank you, Tom, for that. At the risk of going through the agenda backwards, I wonder if we can now actually go, because this might be quite useful, just to get a kind of update from the council, particularly on item 1.4 of the agreement. And this is the first question. There's a reason why I'm asking this question about whether the obligations were fixed as at 2019, the second quarter. And we're now a little bit beyond the track of all that. And Mr. MacLeod has indicated that, in fact, the sums are not fixed at that point, but are potentially updated as time goes by. The reason, Mr. MacLeod, that I raised that, and I'm going to go back to the SIST situation again. When we were having representations in relation to the SIST, the appellant's position was that the sums were fixed already, and that a bill could be submitted, an invoice could be submitted at any point. Now, I would have read the agreement the same way you're reading it and are putting it to me now. But what was put by your firm previously was a different interpretation, that the clause, the contributions were fixed at the 15,938 level, and therefore could be invoiced at any point. And therefore it wasn't right to say that your clients were off the hook effectively, that they could have been billed at that particular point. So the reason really for clarifying that is just to get a real clear indication as to what the appellant's position is as to whether the sums are actually fixed or whether they could potentially increase as time goes by due to indexing. So that's a question for Mr. MacLeod.
No, sir. I'm possibly about to be saved by the fire bell. But
oh, yes.
Attention, please. Attention, please. Fire has been reported in the building.
We'll give
please leave the building immediately by the nearest exit. Do not use the lifts.
Don't use the lift. You reconvene 11:10.
Thank you, sir.
We're not seeing the Shepherd and Wedderburn attendees at their on their screen just yet. Maybe if Mr. MacLeod or Mr. Snedden could advise when you're back, then we can progress. Oh, it looks like they are.
We're just back. Timing was good. Just to give you an indication of what we've been through in the last 10 minutes, we had a constant fire alarm with some automated voice telling us that a fire has been detected in the building. And that happened about every 10 seconds.
Yeah. Hopefully one day it'll not be true. Anyway, so everyone else appears to be back, so yes, when we got to at the stage there just before the alarm, we're looking at the question about whether the sums are fixed and whether in fact the correct interpretation is that the sums, once indexation takes effect, whether they'll now be higher than, and they have 3 years in indexation, the sums that are a burden on your clients would in fact be higher than they were when set out in the agreement.
And that is correct, sir. So I think I've not actually been able to find the email when we were having the correspondence about the CIS, but I think the basic point would be it would be possible for the council to issue an invoice. Now, we accept, based on exactly what you've said, that the invoice would not be for £965,000 or whatever the sum would be. Yeah. It would be 965,000 plus indexation up to the point of invoicing, I believe.
Yeah. I mean, it's worth recording from my point of view that my perspective, I do accept that all these obligations are forward-looking obligations, and that there are circumstances where quantification and precision in the exact sums is more of an art than a science. And it may well be, the council will tell me if this is not the practice, it may well be that the issuing of invoices can sometimes be on a kind of gradual basis, where a best estimate of the sums are sought. Quantification on a more precise level later on will come. I'd like to come a little bit later on in the agenda to the question of overpayment and repayment in that sense, but it's worth just recording my recognition that one of the challenges for the council is, in a forward-looking assessment of this nature, just getting the balance right in what sums are sought from different developers in those different circumstances. Which I think is important to recognise. I don't know if the council, just again, this is probably more for information, and it may be that Vary has this answer, it may be also some of the witnesses an answer to this, whether there's any kind of sense as to what that figure would now be if it was invoiced on the basis of information that's known about just now. And this may be the traffic witness. I saw Chris Nicholas, I say, has now joined the call. It might be useful just as background rather than anything else as to what the kind of level of the contributions as indexed would roughly be, particularly for the west-facing slips, but more generally for the overall obligation as imposed.
Apologies, sir, we're just conferring here as to
Mr.
who will be placed
McCorrison's
to answer this
got his
question.
hand up. Take your time to confer, but Mr. McCorrison may want to speak, or you confer with those in the room with you.
Yeah, thank you, sir. Just to add a wee bit of detail about the process. So when the council issues an invoice, we do a live calculation based on the construction price index, which is notified at that point in time. So what I can't say at this point in time is what that figure would be.
Yeah.
But sir, if it is of interest to you and relevant to the appeal, then I can try and have that calculation done at some stage today and presented either today or at some stage tomorrow.
Yeah, okay. I mean, it's probably just really for probably would be of value in getting a sense, because I'm aware that the last 3 or 4 years, at the risk of understating it, have been unpredictable, and different years because of COVID and the COVID implications have had impacts elsewhere in lots of respects, including construction costs and including a number of issues. And obviously, one of the tests under the circular is the reasonableness of the obligation collectively. So, if it were readily available, it might be quite useful to get a sense of what the sum per unit would broadly be. Again, precision, I think, is and it's only at the date in which you provide it. So I'm not looking for scientific precision, but if there were any information, that would be very useful. I don't know if Harry, you want to say anything more over and above that just now. If not, I was interested actually, and I'll explain why I was interested. The sister report set out a number of assumptions and exclusions, and one of the issues that was excluded was land acquisition costs. And again, Mr. McCorrison may be able to explain a bit about this. Now, it's been explained that the unpredictable nature of these was the reason why they're not included. But I guess if there are staged invoices, the land acquisition costs that would be involved are capable of quantification at some point, albeit perhaps a bit later in the process for the building of the slips. So I am interested in the reason why land acquisition costs were not included in the overall intentions in relation to this obligation.
Sir, from the council's perspective, I'll pass in a moment to Mr. Craig McCorriston to answer this question in a bit more detail. But in terms of the land acquisition costs not being included, the council does anticipate some shortfall in the contributions, and this is built in. The council is also seeking alternative funding where possible, and that all factors into the amount of the amount of money they have available for the works to be done. But I'll pass to Craig McCorriston for further information.
Thanks, Barry, and thanks, sir. Sir, I'm not sure I can add a great deal more to what Barry has set out there. You recognise yourself, sir, that this is very much an inexact science. When the council is trying to predict the cost of infrastructure, it takes a reasonable approach to that. I have to say we're pretty good at it. Where we have a track record of success in terms of delivering very significant pieces of infrastructure, such as the new secondary schools at Winchborough, which are partly related to this appeal because it's that infrastructure which has allowed one of the constraints in Linlithgow on house building to be removed. But we're pretty good. We're pretty experienced at it. We do operate at risk. So if there is a shortfall, the obligation that the council gives is that it will meet the shortfall one way or another, either from its own resources or through additional external funding or through contributions from windfall sites, which are clearly not possible to factor into the calculation in the first place. The reassurance for the developer, and we will come on to this, is that if the council is over-recovering then that money will be refunded in full to the developer. The council doesn't, in effect, make a profit from delivery of infrastructure. In relation to the specific points are about the introduction of the inclusion of land costs. The land that is required for the slips will have limited or no development value. It is essentially verge on the motorway at the moment. There is a little bit of it which is in an agricultural field, but the expectation from the council is that it would pay no more than agricultural value, if indeed agricultural value for that land. So in terms of the overall cost associated with the land acquisition, we expect that to be nominal in terms of the overall project, and that's why it's not been included at this stage. Thanks, sir.
Thank you. That's very helpful. And that point about the relative value of it, because the land is so close, presumably, to the existing junction with its east-facing slips, is very helpful. I should declare an interest, as I'm familiar with the Winchburgh education sites, as I do the parkrun at Winchburgh from time to time. So I know the area there, and I've seen the education facilities that are located immediately next to where the parkrun takes place from. That is very useful, and it's also useful to know that one thing that interested me is once everything gets scratched open through an appeal, is whether issues such as land acquisition costs are effectively potentially up for grabs and working out what the appropriate obligation should be. Obviously, if additional costs come along that aren't in the agreement, the council can't unilaterally decide to go for these. But once an appeal comes along, it had struck me all matters are opened up, and this is something that potentially could arise. So it's useful from that point of view. I'll make up another point in a second, but Vanny's got a hand up just now, so I'll let her finish the council's point, then I'll come to the appellants and Cala.
Thank you, sir. It was just to draw your attention to clause 9.3 of the Section 75 agreement, which you may already be aware of, but it does allow for repayment of developer contributions in the event that they aren't used by the council, and the repayment period is 10 years.
Yeah, I'm actually going to come to the repayment and indeed the question of the repayment period a bit later on. So thank you for that reminder. As a preamble to going to you, Alexander, and then Mr. MacLeod, the main thing that was in my mind, apart from the updated figures in relation to the question about the costs and the land acquisition costs, and actually Mr. McConaston used the word as well, reasonable. One of the tests that is applicable in the circular is that of reasonableness. It strikes me that it could be thought that the decision to seek only partial costs, because the council's position is 100% cost, but actually it's not 100% cost, and I think we've all tended to think, including me, have tended to think of this in terms of an obligation imposed for 100% cost recovery. It is actually less than 100% cost recovery, because the land acquisition costs are not being included. So the reason why it's in my mind is that is a factor, at least, that weighs in the balance of seeing from the council's perspective that they have acted reasonably, looking for the construction costs and the air quality costs set out in the agreement, that they could have included land acquisition costs, but determined not to. So that was kind of the general background, insofar as that plays into the question and the test of reasonableness. But I'll maybe ask you and Alexander to come in, then Mr. MacLeod, any of these issues around land acquisition costs and the fixed costs.
Given my remit here, acting for Cala as an interested party rather than the appellant, I don't really have anything to add. It appears to me that that's more of a sort of planning interpretation point rather than interpretation point as to the Section 75. If Mr. MacLeod thinks different, then I'm happy to revisit, but I wouldn't have anything additional to say on that at the moment.
Okay, thank you. Mr. MacLeod?
Thanks. No, I'm happy to come in and deal with that point. I think just picking up on your issue there about whether the council has acted reasonably in only seeking partial recovery of the total costs of the slip roads. Mr McCorriston's evidence has been that the cost of land acquisition would be nominal to nil. So I don't think that has any material bearing on the question of reasonableness in this case.
I don't think he said nominal or nil. I think he said that agricultural value, which is certainly it is less than development value. But I don't think he's expecting to get the land for nothing.
I have them noted, sir, as saying limited to no value, possibly agricultural, but given the proximity to the motorway, possibly less than agricultural value. You'll be able to watch the recording.
Well, indeed. Well, I'll give Mr McCorriston a chance to comment to the chair, but as indeed we all can, we can look at this later on. Mr McCorriston?
Yeah, thank you, sir. The intention certainly was to infer that it had no development value as opposed to no financial value. So the site is not allocated for residential, for example. So we wouldn't be expecting to pay a residential value on the site. It's used for agricultural purposes at the moment. It may be an expectation from the landowner that an agricultural value would be paid if the site was to be acquired, and I would see that as being reasonable in the circumstances, sir.
Okay, thank you. I think he also, I know there are two related roundabouts that are close to the actual slips themselves, but presumably the land take that's required, there would be land take for the new roundabouts that would be intended. I think they're at the end of the slip that exists already, and one that will go to the new slip. But presumably your evidence, Mr McCorriston, in terms of land take is effectively the same in relation to the land required for roundabouts as they would be for the slip roads themselves.
Yes, indeed, sir. And actually, if you go to the SISTRA report towards the end of it, that there is an indicative design for the slips there, which shows the likely land take, and you can see that is about 50% in verge of the motorway, and 50% is the edge of the agricultural field at the side of the motorway at the moment.
I've also asked in the agenda whether there's any update that can be given, and I'm conscious that we're focused on the west-facing slips, but Mr. Carmichael, if you speak about air quality costs, the cost there of I think 473,000 were estimated, presumably also at an earlier level. I don't know whether Mr. Carmichael is able to say anything about the current state of the estimate of the air quality improvement costs that were previously estimated of that order.
Sir, no, I wouldn't have any information into specifically air quality costs. At this moment in time, it's not something that we can actually put a figure on to the overall improvement costs.
Okay, thank you. Right. We moved in the agenda. We'd moved seamlessly over item 1.3. I've seen the parties' representations on that, and I think we'll come to the two separate issues. I've understood with the council's position regarding the various air quality obligations, the Lithgow Junction improvements generally at Westport, Eastport, and the like, and the west-facing slips to be regarded as being interconnected. I'll come a little bit later on to the extent to which each can be justified separately, so I wasn't going to spend any more time at this stage at item 1.3. I think I'll come to that a bit further on. So looking at item 1.6, and the question that's in my mind really, I think, is played from Mr. Ewan Alexander. First of all, is that of saying, with Cala not being a party to the appeal, and I'm conscious this maybe ties back to what I've heard already on concepts of joint liability. Whether it's open to me to modify the agreement so far as relating to land now already transferred to Cala, and whether that brings in the question of whether Cala would consent to whatever modifications I think fit, given that they're not a party to the appeal.
I think a statement has already been made to the effect that CALA would consider giving consent to modifying principal sums in relation to the traffic improvements contribution downwards.
Yeah, so that would give consideration to.
Yeah, that's the statement position that I'd like to take. Yeah.
How would that operate in practice in terms of what I would do then if it's just give consideration to? That's not a consent as such. How would that work in practical terms if either before or after I issue my decision? The consent afterwards doesn't really help me very much. You'd have to consent before.
I think I'd have to look into that in a bit more detail, to be honest. Oh, sorry, Mr. McLeod, I think wants to intervene now.
Yes, that's fine. I mean, feel free to do so. I mean, it's a practical issue in terms of how issues of consent and the extent of consent would arise, and the detail of the consent at the end of the day. And I'm mindful in looking at questions of what land a decision would relate to, or, as you know, we may come to later on, the question as to whether the right figure is a percentage of something that's higher than 0 but not as high as 100%. How the whole consenting process really works in terms of this appeal process. So I'm giving notice that that's something that's in my mind. So having said that, Mr. McLeod.
If we maybe take that point about is the figure right? That's probably the easiest example to use.
Yeah.
I've certainly seen other planning obligation appeals where the reporter, I think it was a planning obligation appeal, but the reporter basically said, you, the appellant, have asked for, in that case, I think an education contribution to be modified to this value. Having heard the evidence and done some of the calculations, I think you're slightly wrong on what that value is. And what I'm proposing to do, therefore, is modify the section 75 to insert this value instead. In other words, the reporter issued a notice of intention, but asked for the parties' views at that stage because I think the figure was higher than the appellant had asked for. Now, I can provide you with a copy of that appeal decision if that would be useful.
Yeah.
I think from a practical point of view, that would probably be the way to do it. If you felt that the evidence justified a different approach to the one that we suggest you should follow, you could issue a notice of intention that said, I've agreed with you on the principle of a reduction. I don't agree with you on the full quantum. I'm minded to grant a modification on these terms, but I need your consent to do so. And you would invite comments from the parties at that stage.
If you could give me the reference to that case, I'm sure that would be useful to all. But I'll go to the council now. I presume Vary to respond to these issues. We've probably actually rolled together items 1.6 and 1.7.
Thank you, sir. The council's position in general is that a reduction or change in the value of the contribution would require to be agreed with parties on the practical basis that a modification to the Section 75 agreement would be required, and the obligation would take effect upon registration. In order to have the agreement registered, agreement would be required amongst the parties. It may be worth pointing out at this juncture that there is a general ability in terms of Section 75 now for councils to agree modifications to Section 75 agreements with landowners and other interested parties. And as a general point, the council may seek to utilise the modification provisions in Section 75 if, for example, windfall sites came forward, which resulted in the amount of the total contribution being due reducing.
Thank you. that's often up anyway. And I do understand that in asking that question, I understand the primary position of respective parties in this. The council's position is that the full 100% obligation is justified for the reasons we're going to head into very shortly, and the appellant's position is that there's no basis for the obligation. I understand that as the primary position, but it's useful to get an indication as to the way forward if alternatives were considered to be appropriate. Okay, but thank you for that. Moving on to the last of the preliminary issues, and that's paragraph 1.8. And this is the relevance of previous correspondence between CALA, in particular the letter of 30th of June 2021, and the Council on the scale and acceptability of the contribution as proposed. I've certainly seen the correspondence that's come from CALA. Alexander may want to refer to in this regard, so I'm reasonably well cited on the arguments either way. I'm conscious of what CALA said to the Council back in June, 2021, on those issues, those indications in particular as to what they were advising the appellant to do. But I'm also conscious, as far as I'm aware at least, that there's no indication for the appellants themselves as to the question about the acceptance or appropriateness of the obligations. So I'll start again with CALA, perhaps, Mr. Alexander, whether you want to say anything further. As I say, I've read and I think understood the representations of parties thus far, but if there's anything you want to add to what you've said before, then please do.
Thank you, sir. No, I've got nothing to add to that. Thank you.
And I'll maybe go to the Council next before dealing with the appellant's position. If there's anything again Barry wants to add in relation to that correspondence.
The Council's view on that correspondence is it is relevant for context only. In general terms, when determining if a planning obligation is due, the Council have regard to the development plan and other material considerations. In this case, the Council were satisfied that a contribution was due. As the Council understands it, the landowner's liability in respect of that contribution is the £15,938 figure in respect of the land ownership interest that they now have. In terms of other comment that the Council may have in relation to the CALA correspondence, I will pass to Craig McCorriston in case he has any further comments to make in relation to that.
Yeah, thank you, sir. So I don't have very much to say about it, but this, as Barry has said, is context for where we are. This was correspondence that was taking place at the time where the Council was trying to find a planning solution. It wanted to grant planning consent for the site, but there was a difficulty with the Minister having rejected the supplementary guidance, which we'll come on to no doubt in later sessions. So the references in there, the basis of the correspondence was between myself and representatives from CALA, trying to find a way that we could grant planning consent for the site. It was an allocated site in the development plan. CALA were clear, I hope it's clear from the correspondence, that they thought the contributions were justified. They had factored the costs of those contributions into the cost appraisal for the site. And I suppose, sir, if there's a learning point for me in my 36 years of local government experience, it's that no matter what it says in the so I suppose the development management process is focused on communication between the applicant and the Council in trying to seek a resolution. We genuinely thought we had that. We thought we had agreement. I think we did have agreement with the developer. but the landowner was never part of that communication. Clearly, they were part of the agreement on the Section 75, but not on negotiations on the planning application itself. And maybe that's a problem with the planning system in Scotland, who knows? But you know, we got to a position with the developer who wanted to build houses that we would allow those houses, we as the planning authority would allow those houses to be constructed on the basis that we agreed there was a justifiable contribution to resolving the traffic on the high street. So, you know, bear in mind, this is not about necessarily building a motorway junction. It's about recognising the impact that traffic from this development had on the high street. The motorway junction is only the solution to removing traffic from that high street, but this development will feed traffic through the high street. The transportation assessment says that. CALA accepted that and accepted that the contribution was payable on that basis. So I say you live and learn, sir, but that was the basis of that correspondence.
Okay, thank you for that. And in fairness, I had noted that the report to the relevant committee in relation to the application did actually recognise in its assessment of the local planning context, it did recognise the understanding of the council, which sounds like yours, Mr. McCorriston. It recognised the understanding that there had been agreement to that. That was referenced, I think, on two separate occasions in the report to committee. That was at least part of that context and framework within which the recommendation was being made to elected members.
Indeed, sir, and it was my name that was at the bottom of that report, so that was my report to committee. What I can say is that if we did not have that agreement with CALA, that would not have been the report that was taken to committee. There would have been a different recommendation on that report.
But I'll go now to Mr. MacLeod and then give Mr. Alexander, Ewan Alexander, a chance to comment if there's anything further to add. Mr. MacLeod first.
Not very much to add, sir. I mean, I think the position is set out in the previous submissions, and as has been discussed, all my clients signed Section 75 because they had to as landowner in order to secure the planning permission. They did not agree to the contribution, and they are exercising their statutory right to have the legitimacy of that contribution tested through this process.
Okay, and Mr. Alexander, anything more? You may have a little more to say, but just to give you that last word.
Yeah, no, just to confirm, I don't have anything more to add. Thank you.
Okay, right, thank you. I think that concludes all the preliminary issues. And moving on next to section 2, I'm inclined to keep going. We had a little bit of a break, but unless anybody feels the need for a further break at this stage, and maybe break slightly earlier for lunch, but I'm inclined to press on and move on to the substantive issue, starting with the west-facing slips. And I think at this point, perhaps slightly conveniently for communication round the room, I think you and Alexander steps out effectively. He's happy to remain in the meeting if he wants to. Namesake Rory Alexander now takes over from Barry Foy, so that's at least convenient for my communication with people in the room. So I think that's my understanding of kind of next steps as we move into section 2 of the of the hearing this morning. So if that is right and makes sense. Section 2, to some extent, I've got a couple of preliminary questions, actually, just on factual basis for my benefit. To a certain extent, I'm going to go to the council, first of all, just to kind of go through just a kind of further exposition of the kind of the policy context that justifies the imposing of these obligations more generally, before we come to the questions in relation to scale and kind that we'll do later on in terms of the link with the development and the LDP basis for the obligations. They may want to just give through either Steve or Stephen a kind of summary as to where they're coming from and where they are in relation to that. And a couple of factual questions, though, I just wanted to get a sense from parties, and it may be that Dr. Kelly could come in with us as well. And that's kind of three questions. Just for the record, effectively, the Deanburn road site, how far is that from the high street? How long is the drive, typical drive from the Deanburn road site to the high street? And there was a suggestion that it's beyond walking distance, and I just wonder, I presume that's a sort of typical indication of walking distance. And I know, having been at the site, it's a bit of a hill going up there, up to Deanburn Road. But whether it's thought of being as beyond a kind of typical walking distance. I'll go to the council first of all, if you have that broad indication. And if you don't have precise answers just now, we can provide it a bit later on. But I'd say the three questions: how far from the site, how long is the drive for vehicle users, and could it reasonably be said to be on walking distance?
I'm looking around the virtual room to see who might want to take that one on, sir.
So I'm happy to take that on in terms of a broad indication. So we can get actual calculations, and transportation colleagues might be able to do the calculations while I'm speaking. So I suppose that the starting point is that the high street itself is very linear, and kind of starts at the low port and ends at the high port, and itself is probably, I would guess, about a mile long, 1.25 miles long. The Deanburn site is essentially sitting at right angles at the western end of the high street. So I suppose it depends at what point you measure it to the high street. But if I was taking it to the closest point of the high street, I would say it is about 3/4 of a mile. These are my estimates based on my knowledge of the town. We can do an exact calculation. The site itself, the Deanburn site, spreads sort of east to west, if you can accept that categorization of it. So the furthest most part of the site will be a little bit further away from the high street than my. So I'm basing that at the closest point. In terms of drive time, main road is Preston Road that accesses the high street. There's no traffic lights or anything like that. There's a bit of traffic calming on that road, but I would say that travel time by car to the closest point of the high street would be, given no congestion, that there is a school on the site, there's a school crossing patrol, so that could add to it. But I would say around 2 minutes drive time to the high street. Is it walkable? It's certainly walkable down the way for an able-bodied person. Would somebody with a bag full of shopping want to walk back up the hill reasonably? So they could do that. It would be reasonable, but it's a bit of a climb going up there. So that'd be my characterization of the access from the site to the high street. Obviously, if you're looking at the far end of the high street, where the east end, where the railway station is, for example, or the centre where most of the public houses and cafes are, then it's going to be a bit more than that. These are the distances to the closest point of the high street, which is not the most commercial part of the high street, for want of a better description. The commercial part being the town centre itself in the middle of the high street.
Okay, that's useful. I don't know if anybody else from the council has anything they want to add to that before I go to others.
Yes, so Steve McLaren, who's the case officer, has his hand up.
His hand up, yes, indeed. Thanks, Steve.
Good morning, all. It was just to say I've done a very quick measurement on our GIS system for this, and as the crow flies from Deanburn Road, its easterly corner, if you like, it's about 855 metres down to the junction, Bumpler Preston Road and High Street. From that junction along to the roundabout at Westport, so the Regent Centre where you've got Tesco, it's about 915, 920 metres along there, so it's almost a kilometre. As Mr McCausland points out, that the kind of commercial element to the high street sits further along that side, closer to the cross. So if you were to take a distance from the bottom of Preston Road to what was our old offices at the cross, then that's around 675 metres. And yes, it's walkable distance. It really, I suppose it does all depend on your mobility and how easy it is for you to walk up Preston Road coming up or along the high street.
Mr McLeod, is anything to add in relation to that before we go to Dr. Kelly?
I'll hand over to Mr. Snedden, who I think has got a helpful document to refer you to.
Sir, it was just to draw your attention to document A018A, which is the transport statement, part A of the transport statement, and page 28, which includes a plan showing the site, some as the crow flies type isochrones and the various facilities within Linlithgow. If we're talking about shopping, then if you do have a look at this afterwards, we'd highlight that although there's the main retail areas in the high street, there's also the Stockbridge Retail Park to the west. Yes. And I would also highlight that there's a pretty direct route which is well used, which is the towpath for the canal. So that's the most direct route to, for example, the railway station.
Okay. Thank you for that. And Dr. Kelly?
Yes, thank you. Yeah, I think the figures have already been given. You could say it was just slightly over a mile to the cross, and a wee bit further than that to the station. But if you were walking to the station, then you would use the canal towpath. So you're talking about a mile. I think the information that was in the planning officer's report, from memory, talking about a 20-minute walk. I think that it would be a 20-minute walk if you were. I tell a lie. That's not the planning officer's report. It was the planning report from Carla. 20 minutes would be a very active walk, let's say. So certainly it would take more than that to get to the station and back. The issue regarding driving, which is of course how most people are going to get there, is complicated by the fact that there's no parking at the other end. So beyond a sort of 7:30 in the morning, probably the only car park that's got space for parking is either Tesco's with a 2-hour limit, or the car park at the sports centre, which has generally got a few spaces at that time of the morning. I noted on my recent walks. That itself is a fair step from the station. So I think taking the car to the town is just going to complicate things further. People will, of course. I mean, they'll probably pay to go into the Vennel, but it just causes more and more congestion and more problem as far as parking is concerned. Thank you.
Okay, thank you. And this was a follow-up question, and I may ask this to Mr. Snedden first of all, or others may have different views. Is that looking at this particular site of 60 houses, and they are quite substantial looking houses. Do you have any information, or you could refer me to documentation as to what your normal planning assumption would be as to how many cars would be broadly liable to be owned in a site of this kind of size, retailing at the sort of prices that it's likely to sell for?
So car ownership isn't usually something that we try and calculate because we're really interested in car usage.
Yeah.
And in relation to the usage, for peak times, which is what the transport statement looks at, that information is contained in paragraph 4.8 of the document reference I just gave you.
Okay, thank you.
Which, using agreed trip rates, is 26 vehicles in the morning and 31 in the evening.
Yeah.
Peak hours.
Does anyone from the council want to comment? Sorry, I beg your pardon, I didn't mean to cut across you.
I was just about to say that I was just reading the rest of the paragraph equivalent to that, equivalent to an increase in traffic movements of about 1 vehicle every 2 minutes.
Okay.
And I had just one general observation, which is car ownership's one thing, usage of cars is another. And just picking up on Dr. Kelly's point about the difficulties with parking in the town centre, the lack of availability of parking as a general rule would make it less attractive to use your car than more. And so the absence of parking may in fact deter people who live in this development from using their car in a way that they would otherwise do if there was plenty of parking.
Okay, thank you. I'm going to go to the council, Craig, because got his hand up. Whether it be car ownership or car usage, whether it's my looseness of language, I don't know if there's any comments you want to make about that general question of the sort of usage that would come from a estate of this size and nature.
Yeah, thank you, sir. And again, transportation colleagues may wish to add to this. I mean, in terms of the number of vehicles, I mean, it's not unreasonable to expect there'll be at least 2 cars for every house up there. So 120 additional vehicles that are using the town streets, for want of a better expression against that. What the transportation study says is that, and just bear with me for a second, 58.3% of the trips from the site will be by car. So we've got the details of what the morning and afternoon peak movements will be. 26 vehicles and 31 vehicles each way in the peak, but 58% of all movement from the site by the applicant's own transportation assessment will be by private vehicle. Now, reflecting on the council's position and the comments made by Dr. Kelly at the start, the principal issue that the council is trying to address is transportation traffic congestion on the high street. I say we'll come on to the motorway junctions, which are one of the solutions to that. But the issue that the council and the community is trying to address is congestion on the high street. 58.3% of traffic movements from this site of 60 very large houses will be by private car, and that will inevitably, in the council's view, have a significant impact on the transportation situation on the high street as it exists at the moment. The council is pursuing improvements to the high street and is looking at options to achieve that, but it is clearly the council's position that if we can't get a solution to the high street, then it will not support further development in the town because of the impact that will have on the high street. Thank you, sir.
Okay, thank you. I'm going to go first of all to transportation witnesses for the council, in case you want to add anything to that. I think Dr. Kelly's hand is still up, if I'm reading this correctly, so I'll come to him afterwards if it is. I'll just give an opportunity for transportation witnesses for the council to say anything or add anything. Okay, Victoria?
Thank you, sir. I think Craig summarised that really well there, but I think the only thing that we would add is that the figures that he's given, the 124, obviously we have to consider as that doesn't take into account any additional trips by visitors, deliveries or pickups and drop-offs to and from the station.
Okay, thank you. And Dr. Kelly?
I agree with most of what Craig McCarthy has just said. The issue here is that people will drive straight through the high street and beyond, so that a large number of people won't actually be going down to the town centre from this particular development. They'll be going elsewhere for entertainment and shopping and the like, and that is a problem which the town has got as well. I'd also point out that there are only 5 buses per day going up in the direction of Preston Road, so that there really isn't an option for bus travel as opposed to walking. And I would agree with the statement that was made that the majority of journeys will be made by car. On the subject of time, it's worth mentioning that in the report that Mr. McCarthy has referred to, the SISTRA report, it says there that the majority of people in the high street, driving the high street, will stop at least 4 times. So it's not unusual for in times when the high street is congested for a journey from one end to the other to take at least 10 minutes. Thank you.
Thank you. That's all very useful. I just looked to Mr. Snedden. Just if there's any last comments you want to make in terms of what you've heard after your last intervention.
Yes, thank you, sir. I just wanted to come back on the point about the trip rates not being representative, despite the fact that they're in the submitted transport statement. The trip rates are extracted from surveys of the actual houses on Deanburn Road. So if there were deliveries going in there at peak times, or trips going to the station and then coming back again, they'd be counted in these surveys. So they are reflected in development trip rates.
Okay. Thank you.
And my only other observation, sir, and it's a minor one, but Mr. McCarson was very keen to repeat the mode share point on car trips. I wasn't clear where in the document he got that from. I'm currently looking at a table, and I may be wrong on this, but table 3.2 of the approved transport statement refers to potential development mode share / person trip 2-way. So that's page 16 of document A018A, and table 3.2 shows a mode share of 55% for car driver, but in real terms, what that equates to is 26 trips. And that's perhaps the figure that needs to be focused on, 26 trips, rather than 58.3. And as I said, I don't know what the origin of that figure is.
Yeah, my recollection was that I'd spotted that 55% figure as well. I wasn't sure if this comes from the same place or whether that's rooted in somewhere else. But it's certainly of the order of 55 to 58. But certainly you're right, Mr. McLeod. The figure I'd spotted was a 55% figure. But Mr. McCarthy, I don't know if you want to add anything to that.
Yeah, sir, happy to accept the 55% figure. If you look at the table above, it gives an additional for car passengers of 3.4%, I think. So it was the addition of car drivers and car passengers that was giving my figure. But if we want to focus on just those car drivers, then the difference is not significant. The point is that the vast majority of trips from the site will be by private car.
a slight majority. I think 5%, describing 5% as the vast majority is something of an overstatement.
Okay, thank you. Okay, thank you for that. That's immensely useful to me, just setting a little bit of kind of contextualization of that. In terms of back to one of the agenda, I've certainly seen the representations, and I think I understand the position of the council in relation to the kind of local development plan context. I'd like to talk maybe a little bit about the examination report. I don't know, Mr. McConnerston, if either you or your planning witnesses want to expand anything as to what you've said, as to the general justification of these obligations in terms of the planning context. I think, as I say, I do understand the arguments that have been put forward, but yeah, I wanted to give you an opportunity to expand on that, and I'll ask a couple of questions about the LDB examination report in a minute.
Yeah, so given your position that you understand that context, then I don't think I need to add very much to that, other than to re-emphasise the point that Linlithgow was in previous development plan status an area of restraint, and the council only agreed to remove that area of restraint on the basis that there was a realistic prospect of removing the constraints that led to that position. One of those being the very significant education constraint. The Linlithgow Academy was consistently over subscribed, leading to significant challenges. We were able to resolve that position with the schools at Winchborough, which we had a financial commitment to at that stage, which only left the issue of the environmental capacity of the high street and the whole basis of the allocations, which then went into the current local development plan, were a development-led solution. The words of the reporter, not necessarily the council, but the reporter at the examination, that it was appropriate to have a development-led solution to removing the constraints on the high street, or the environmental difficulties in the high street. So that led to the position which we are now in. So, Sarah, I think I can leave it at that, and we can pick up any of the more significant points in individual questions, and certainly Steve Lovell will be able to respond to the LDP examination report.
Yeah, okay, that's fine. Maybe just, the question I had really in relation to the LDB examination report, I mean, both parties in this appeal cite references from that report that what eventually did become the 2018 LDP. The bit I wanted specifically just to kind of to moot and to speak the views of parties. I'll start with the council and then Mr. McLeod on both these issues together. What is the relevance of the Supreme Court decision in Elsick, and what that means for the interpretation of these obligations and the interpretation of the circular? I was intrigued to see that on rereading Elsick, that it was decided in October 2017, and the LDP examination was completed in November 2017. There's no reference to Elsick in the report, and I'm kind of working on the basis that the examination was no doubt as lengthy an examination as these things normally are, and kind of predated the views of the Supreme Court in Elsick. So I wasn't really looking to draw too much from the examination report as a critique of what Elsick meant on developer contributions, just because of the kind of proximity of the timings of the reports. But I don't know if either the council or the appellants have a different view on that. It did seem to be so close in time, with the Elsick decision roughly a month ahead of the examination report being submitted. It did seem unlikely to me that the reporters had given serious consideration to the implications of Elsick before completing the report. But if either of you take a different view, Yeah, feel free to say it. Mr. McCorson on that point first, then I'll go to Mr. McLeod generally on the policy background.
Yeah, sir. Well, you're ahead of me there, because I hadn't looked at the timings of this, and you know, I suppose all I can say is that my expectation is that if ELSIC was a significant factor in terms of the terms of the local plan following the examination, then there was still a further intervention where ELSIC could have been brought in. So although we had the examination report, which was around the same time as ELSIC, the adoption of the plan was some time after that. So if it was non-compliant with the terms of ELSIC, my expectation is that the Scottish ministers would not have allowed the council to proceed with adoption of the plan, or indeed, you know, if there was some significant relevance, then I would have expected the reporter, the examination reporter, to have made some further comment in the process, given that the plan hadn't been adopted at that stage. So I can, in terms of the process, I'm not sure I can offer anything other than that, sir. Well, what I would say is that the council is satisfied that ELSIC is not a significant material consideration in terms of its approach here. The council is satisfied that we are taking a cumulative approach, which is allowable under the terms of the relevant circular, and that the deficiencies at ELSIC were of a different magnitude and a different problem. I would be happy to explain my thinking on that a little bit further if that is necessary. But suffice to say at the moment that there was no direction from the ministers not to adopt the plan because of ELSIC, and the council does not believe that ELSIC is a significant material consideration. Thank you, sir.
Thank you. I mean, I'll go back to Mr. McLeod just now. I mean, it might be quite useful to get a little bit of a further elaboration from your rationale behind that, but I'll go to Mr. McLeod first of all.
Thank you, sir. I've been flicking through my papers trying to find a specific reference, and I can't at the moment, but I'll give you the general point.
Yeah,
so,
okay.
Responding to Mr. McCorson's last point first, he makes the point that he would have expected ministers to intervene if they felt that the policy, if there was an ELSIC issue, if I can put it that way. My position on that is there was no need to, because the reporters actually did their job for them. And what you will find, and I can put this in the closing submission to make sure you've got the specific references, what you will find is that it was the reporters who modified policy INF1 to make specific reference to the interpretation of the circular in line with emerging case law. And in my submission, there can be no doubt that the reason that the reporters put in that specific wording was because they were generally aware of what was going on with ELSIC. And although they didn't come back out and ask parties to further submissions and so on, and there may be reasons for that linked to the length of the LDP examination, that is speculation. But what they did was they included specific words that meant it was unnecessary to get parties' views on that issue, and it was unnecessary for the ministers to intervene. The important point in all of this, Mr. McCorson says that ELSIC is not an important material consideration, and there are factual reasons he says that. But the important point is that ELSIC and the circular are baked into the council's policy on infrastructure contributions. Policy INF1 makes specific reference to the circular as interpreted by emerging case law. And so when one comes to consider the meaning of INF1 and its application, you have to apply that in the context of the circular and the decision in ELSIC. That is what the policy says.
Mr. Carlson?
Well, sir, thank you, and thanks to Mr. MacLeod. I think that's, if anything, helpful to the understanding of the position, because if the reporter did have regard to LSIC and had, as Mr. MacLeod suggests, amended INF 1 specifically to address LSIC, then it must therefore follow that everything else in the plan would be compliant with LSIC. And the position in the plan is that the reporter at the examination said that the undeveloped sites in Linlithgow should fund the transportation interventions which were necessary. So therefore, by implication, if LSIC had been built into INF 1, it must therefore follow that the reporter's logic in his approach to a development-led funding of the infrastructure in the town must therefore also be compliant with LSIC. Thank you.
Mr. MacLeod wants to come back on this.
You sensed correctly, sir. And it leads on to a point. Maybe helpful before I say what I'm about to say. Could Mr. McCorriston just clarify that is the council's understanding of what the LDP examination did? Is the council's understanding that the LDP reporters were effectively saying the slip roads should be funded by only the 6 development sites that were allocated? Is that the council's position?
Sir, I'll let Steve Lovell add a little bit on this, but I think it was slightly broader than that. So the reporter identified 9 sites in the town. The reality is that some of those sites already had planning consent, so therefore were beyond the ability to secure developer contributions from them. So there was a difference between the 9 sites and the 6 sites which were covered by the supplementary guidance. But in essence, the developer, the reporter accepted the general proposition that to allow development to proceed in the town, the constraints had to be removed, and that though the removal of those constraints would be development-led.
Okay.
Sorry, on you go.
Okay, yes. Mr. Blair.
It links into a point that's made in the council's response to the appeal. I'm not sure that actually has a document number, but it's the response that the council made when we submitted the appeal.
Sure.
And in paragraph 3.5 of that document, it says, in the event the West Lothian local development plan allocated 9 housing sites in Linlithgow, with 6 identified as overtly requiring to contribute towards junction improvements, as well as to a new motorway slip at junction 3 of the M9. Now, I'd like to know where in the LDP is that overt reference, because I can't find it.
So I'm hoping that Steve Lovell will be able to assist with that. And I see Dr. Kelly has his hand up, so maybe Dr. Kelly can assist.
Thank you. Just a couple of points. The reporter's comment in the examination report of the local development plan stated, I accept that the plan only contains a limited amount of detail on the mitigation measures that may be required. And in fact, the objections that we put forward to the draft plan majored on the lack of information about infrastructure. it does also say, the reporter also said, the development management process has a more significant role to play in addressing the transport issues in the Linlithgow. And I think that mirrors the approach that the council were taking at that time. And one of the things that we discussed at Planning Forum meeting recently was the implication that the National Planning Framework 4 states that development proposals which provide or contribute to infrastructure in line with that identified as necessary in LDPs and their delivery programme will be supported. So we're sort of rather hopeful that the interpretation of the National Planning Framework now gives more credence to the fact that we should have had more information in the local development plan, and presumably we will do in the future. Thank you.
Okay, thank you. Just before going to Mr. Lovell, who may have the answer to the question that Mr. MacLeod has answered, has asked rather, when I was looking at the papers here, the reference to the 6 sites that I'd identified was in the supplementary guidance from memory table 14. I think that the point that Mr. MacLeod had made, that it wasn't in the LDP itself, certainly I hadn't seen it. Mr. Lovell may correct me in all of this, where I derived the information about the sites required to make the contribution was, as I say, from memory table 14, but in the supplementary guidance. Mr. Lovell, you may have a more exact answer. You're on mute just now, so thank you.
Steve, thanks. So we were just conferring internally there. Yeah, I mean, the direct answer to the question is that you'll see through the LDP process that the area of restraint was lifted so that 9 new sites could be allocated. Yeah. So that is the answer to the question. In terms of the LDP, there's 9 new sites, and the reasons, as Craig has already alluded to, for lifting the area of restraint were twofold: education, which has been resolved, and also transport infrastructure, and in particularly to alleviate the issues of the high street, which we've obviously touched upon already today.
Yeah. Thank you. Is there anything else Mr. MacLeod wants to say on this point?
Yeah, yes, sir. So the council's position seems to be that the LDP examination resulted in some way with the LDP imposing an obligation on all of the allocated sites to make contributions towards the site, come on to the proportions and so on in due course. My submission is slightly different, because what the LDP examination reporter said is, you've given us some information. We recognise that there are some transport issues in Linlithgow, but you've given us information. People have objected to that. They've said there's not enough information. I think that was Dr. Kelly's point from earlier on. And what the reporters did was they effectively deferred the question of what should contribute and in what proportion to the supplementary guidance. And you can see that from policy INF1 itself. The council will seek developer contributions in accordance with the circular as interpreted by emerging case law and as amended by subsequent amendments in legislation to mitigate the development's individual or cumulative impacts on infrastructure, including cross-boundary impacts. Supplementary guidance explaining how developer obligations will be implemented will be developed during the plan period. So, in fact, I'm sorry, there is one other paragraph, and this is mentioned in our response to paragraph your question 2.1. Infrastructure requirements are identified in Appendix 2 and further details will be provided in subsequent supplementary guidance and the action programme. Any related planning obligations will require to meet the policy and legal tests set out above. That's the circular and LSIC. And then it says proposed sites for new infrastructure are listed in Chapter 6. What it most definitely does not say is that all of the sites allocated in Linlithgow will have to contribute towards the slips. What it says is that contributions are to be based on the circular as interpreted by LSIC, that supplementary guidance complying with those parameters will have to be produced, and that sites for new infrastructure are listed in the LDP. Now, we accept that the slip roads are listed in Chapter 6, but nowhere in the LDP does it say that this appeal site must contribute. That was an issue that needed to be taken forward and considered on the basis of the evidence that supported the supplementary guidance, because there was insufficient evidence available to the LDP examination reporters about whether it was appropriate to have all of the sites, some of the sites, or none of the sites contribute to the slip roads.
Was it insufficient evidence, or did the reporters take the view that that was effectively too much detail for the examination stage?
It's a good question, sir, and I genuinely don't know the answer to that. They may have felt that it was a level of detail too far, but what is clear is that they did not take a decision in the LDP that this appeal site should make any contribution to the slip roads. What they said is that that is for another day through the supplementary guidance process, and of course we'll come on to see what happened with that in due course.
Okay, Mr. McConaston or Mr. Lovell?
Oh, sir, I explained earlier on, I'm just having a wee bit of a challenge here because I'm working from home, so I've lost access to some of the sites.
Okay.
What some of the documents, there is references in, Mr. MacLeod is correct that not all of the detail was included in the LDP. And my understanding is because it was a level of detail too great for the LDP, and that's why supplementary guidance was required. But there is a general principle from the reporter that the development in Linlithgow was only acceptable if the sites that were being allocated were to fund the infrastructure that was necessary to support that. And we will find you the reference to this. I'll make a reconnection at lunchtime if necessary to pull down the relevant documents if Mr. Lovell isn't able to find them at the moment. But there was certainly a general principle and acceptance that this was a development-led approach to the resolution of the infrastructure difficulties in the town, without it being specific about what contribution should be made from any one of those sites. But the understanding was that the 9 sites at the time would be the solution to the transport infrastructure in the town, and that is firmly my view of what the reporters were thinking. But we will find the references to that if Steve isn't able to do that at this point in time.
Okay, Mr. Lovell.
Sorry, I may be able to add just to that. The reference to this is in it's paragraph 2, page 63 of the examination report. The reporter said there that he noted that many of the reasons why the area of restraint was initially applied in the Linlithgow area local plan, that was a preceding local plan, continued through to the current local plan, remained relevant today. And he said these included protection of landscape setting and specifically traffic congestion, lack of parking, and also environmental impacts. He accepted that some of these matters had been partially addressed, but he noted that constraints on the transport networks remained, and concluded that there was capacity for some development. He also noted that some progress had been made on that action in relation to town centre air quality. He went on further to say that the policies that the plan have would allow development to be considered as part of the development management process, accepting that development could help facilitate the mitigation of concerns relating to infrastructure, and in particular, development is required to secure the required funding for the proposed slip roads of the M9. So that's specifically stated at paragraph 8 of the reporter's examination report.
Okay, thank you. Now, I've got Mr. Alexander's hand up just now. I haven't heard from the council lawyer for a bit, so.
Thank you. I just thought it'd be useful, to focus on the LDP itself, given some of the comments made over the last few minutes. And to me, the LDP is clear in that Craig's talked to us about the history about lifting the area of restraints. And through the LDP process, 9 sites were then allocated in terms of page 88 of the LDP. Congestion issues in the town centre had to be addressed, so the traffic volume, traffic speed, and the resultant air quality issues in the high street had to be addressed. The LDP safeguards lands at the western slips at paragraph 126. So again, in the LDP. The infrastructure policy INF1, we've talked about what it sets out, but it makes specific reference to how this will be identified to the SG and the action programme. Now that's important. Now we do have the action programme. We can no doubt talk about the issues with the SGs, but we do have the action programme, which is specifically referred to here. And on the face of it, it's quite clear from the action programme that infrastructure requirements for the appeal site set out at pages 150 and 151, that there will be contributions required for the westbound slips and other development contributions towards transport infrastructure. So me as a developer coming to the area, I suppose your first protocol is to look at the LDP, and that's what I see. I see a newly allocated suite of sites for the town. I see there's issues in the high street, and to resolve them, we need a transport solution. And that's set out in the requirements in the LDP, along with the action programme. I suppose the other point to mention, which has been touched on chapter 6, on page 88, obviously identifies the M9 slips at P44 and also the Linlithgow Town Centre traffic management measures at P115. So again, just on the face of it, when I look at that LDP, I haven't been involved in the history behind it, others have that can speak to it. I suppose I focus on the LDP as is, and that's what I see.
Thank you. Now, is there anybody else, Mr. MacLeod, is anybody else wants to make any further representations on this point? Mr. MacLeod.
Just coming back to Mr. Alexander's point there, I mean, with respect, if a developer was coming to the LDP and was trying to understand what their obligations might be, in my submission, the best place for them to look would be Appendix 2, which is the schedule of housing sites and the site delivery requirements for each of those housing sites. Now, we've said this already in the response to your questions, sir, but nowhere in Appendix 2 does it give an indication that the appeal site would require to make any contribution to the slip roads. And we will come to the action programme in due course. But the action programme, sir, is a document which is separate to the LDP and any supplementary guidance that forms part of the development plan. The action programme is effectively a project management tool that sets out how policies and proposals within the LDP are to be taken forward. Now, the council, I think, has accepted that there is no policy in the LDP that specifically says this site should contribute towards the slips. Therefore, the only policy that the action programme can relate to is the supplementary guidance. And again, we'll come back to that in due course. But the action programme is not a policy document itself. It simply sets out how approved policies will be implemented in practice.
Thank you. Mr. Alexander, anything further on this?
Hopefully what I've said earlier is clear. I think it's perfectly clear on the face of it, and I don't seek to repeat what I mentioned earlier.
Okay, thank you. I was going to move on though, maybe deal relatively briefly with the two other points, like paragraph 2.2 and 2.3, that I'd addressed as issues that had struck me in looking at the way in which the various obligations are constructed on behalf of the council. And at one level, there are sort of slightly peripheral comments, and I've certainly seen the council's response to each of them. The reason why they kind of piqued my curiosity in this was in relation to the fact that the identified sites are being expected to contribute to the extent of 100%. It was a level that is considered as being justified by the council. I suppose in relation to the industrial sites, reading that, there seemed to be, to me, a bit of a kind of mismatch in approach between the industrial sites and the housing sites, where the housing sites are kind of almost as if they are being presumed that they will contribute towards the cost of the roads, unless it can be shown that they don't, whereas the industrial sites are being presumed not to contribute towards the need for their road improvements unless it can be shown that they are. And I was just interested, especially if the sum that's being sought is to match 100%. And I'll come in a minute to the question of repayment, as to whether there was a bit of a kind of mismatch in that respect of what seems to be a slightly different approach that's been taken to the industrial sites that could contribute in terms of the SG and its reference to 3.54 and 3.55. But I wonder whether Mr. McCorriston or his planning witnesses have anything further to add, just in terms of how that had sort of the perception I'd had on looking at all of this together.
Yeah, thank you, sir. And your perception is correct. They are being treated differently. So that doesn't mean that they won't contribute. But the expectation is, particularly with the industrial sites, that they will go. They will be developed at a much slower rate than the housing sites. It is clear from current evidence that Linlithgow is and has been for a long time an area of market demand for housing, and the expectation was that the 6 housing sites that will contribute would contribute quickly. The industrial sites, on the other hand, particularly the one on the north side of Blackness Road, is a very specific industrial allocation. It's not there for wiggly tin sheds to go up. It's there if there is a development of national significance or certainly regional significance. So an expectation that we might get the headquarters of a bank or something like that coming forward, or a significant inward investment. We still hope that we will get that, but the reality is that if we do, it's likely to be on a much longer timescale. If somebody comes along and we are minded to grant planning permission, then the supplementary guidance, as it stands at the moment, says they will contribute. But we heard earlier on that the timescale for the repayment of money on the transportation contributions is 10 years. So we run the risk of gathering the money from the housing sites, and then if we hadn't included assumptions about the industrial sites, we would then have needed to have waited for those until we had the full funding in place, if you follow me. That could reasonably be beyond 10 years, which brings us into the position that we would have to refund contributions which we had already gathered. So it was simply a practical realisation or expectation in terms of how quickly those sites would come forward, but with that reassurance that if they do come forward, contributions would be sought on a windfall basis.
Okay, thank you. You're actually anticipating my next question, which I'll pose before I go to the appellants on this, and that's I think your hearing statement indicated that this obligation has been imposed already on one site, one of the Mance Road sites, I think. It's been imposed already maybe a couple of years ago, and so the question that was in my mind is actually ties in with what you've just said, Mr. McCorson, is about the kind of the 10-year cycle in all of this. Because of that site and because of this obligation, I'm kind of taking it that in effect the imposing of these obligations kind of commits the council to the building of the west-facing slips within 10 years, either 10 years of the site that's been granted the Mance Road site already, or within 10 years of this site by 2032. Because if you take more than that, building on the point you've just made, if more than that time is taken, then the situation becomes one of potentially having to repay the sums that you get. And the related question to that would be that if it takes more than 10 years before the west-facing slips are built, it at least begs the question as to whether there is truly a link between this site and the west-facing slips if it takes more than 10 years for it to be built. So it would beg the question as to whether there is in fact a true connection between the two. So I suppose my question is are the council in effect now committed to building the west-facing slips within 10 years? Is that the consequence of what you're saying? And that would relate whether or not all of the 6 sites identified get planning permission.
Indeed, sir. So I'll try and there were a number of
there's a few things in there. Yes, apologies.
I'll try and work through those. So I think the first one was have we gathered any contributions already? I think you spoke about one of the Mance Road sites. Yes. It's actually the site, and apologies, I don't have the LDP in front of me, but it's the site opposite Sun Microsystems.
Oh, yes.
That has been developed, and a contribution has been made there. It's actually the same developer that is developing the site in question. So that contribution has been made. We have also gathered a small number of windfall contributions from windfall applications, and we have applications on at least one of the other allocated sites in the local development plan. It was a site that was refused on appeal for a number of reasons, not least that the site was allocated, I think, for 200 houses in the development plan, and the proposal before the council was for half of the site, and it was 400 houses on that site. That was refused by the council, I think, possibly appealed against non-determination, but in any case the appeal was dismissed.
Yes.
So we have a number of sites coming forward now. The council will commit to building the motorway junction when it has a reasonable level of contributions towards that. At the moment, we've got 1/6 of the cost. If we're successful in defending this challenge, we will have 1/3 of the costs of the motorway junction. We continue to look at external funding sources. We made an application to the UK Levelling Up fund that was unsuccessful, unfortunately, but round 3 of the UK Levelling Up fund bid process is forthcoming, and we understand that's going to be an allocative award as opposed to a competitive award. So there's at least the prospect that that will contribute a significant contribution towards the motorway junction. It will be for the council to decide how it uses that money if it's successful in securing levelling up fund. But there's one scenario there, sir, where in a relatively short time period, we could have the majority of the money committed to the motorway junction. And at that stage, the council will commit to delivering the motorway junction. So how long is a piece of string? How quickly do these applications come forward? How quickly can we secure the contributions that give us the certainty that we can move forward with delivering that project? Hopefully, so that covers all of the points you made. I sense there might have been another couple there that I've missed in my response.
No, I don't think so. It's not so much how long is a piece of string. I guess, but it is going into kind of future speculation as to the sort of timings. And I think what you're saying is those timings will have an interrelationship between the bringing forward of other sites and the ability to impose the obligations concerned.
Indeed, you know, in an ideal world, we would be in a position as a council to forward fund the development, as we have done with the schools at Winchborough, where the council would borrow and then recover the costs, and that would deliver the infrastructure much more quickly. The reality of the financial position of the council is that we are not in a position to do that, unfortunately. But you know, at the point where we get a significant level of contribution, we may be prepared to look at options for funding the gap to allow delivery on a concertina timescale than would be necessary if we waited until we had every last penny in to deliver the project.
No, absolutely, and that does all these things tie in with the level of contribution. And the reason I asked these questions is I think there's something the Planning Forum had said in their representation about this whole issue begging the question as to who's going to pay for the road. Effectively, now no doubt Mr. MacLeod would say it has to be paid for by the right people to the right extent. But really, my interest in the timescale for when the trigger point is going to be reached that the road is committed to is kind of tied into that question of the 10-year repayment. And that once you get to the stage where you've gone to the 10-year phase, either for the existing site, which has got I think a 2018 permission already, or this site, if it's not sorted by then the council will be back into repayment territory. Let Mr. McCarson come back and then go to Mr. MacLeod for his response on all of these issues.
Yeah, and so it was simply to make the point that you know, in terms of a project of this scale, which will be delivered over probably something like 3 years, there will be phased payments on that. So really, the way I'm looking at it is the trigger for commencing development is the 10 years from the first contribution which we have. But that doesn't necessarily mean that the whole project has to be funded at that stage. You know, if we take our experience from delivering significant infrastructure projects, we tend to make phased payments to the project. But the desire of the council is to ensure that we have a commitment to all of the funding at the point that we effectively press the button on the project, and it's that pressing of the button that would have to be within 10 years. Otherwise, we run the risk of having to make essentially repayments of the contributions gathered.
Okay, thank you. I've got further questions of repayment, but I'll go to Mr. MacLeod first of all.
I don't have very much to say in response to that. There are some points about actual delivery of the project that we'll come back to, and that links into things like statutory permissions and the involvement of Transport Scotland and so on. But I appreciate that's a later point in the hearings, sir. 5 minutes, please. The main point though was Mr. McCorriston had indicated, and says so in the hearing statement, that contribution rates in relation to windfall sites as well as industrial would be levied based on trips generated. And Mr. McCorriston fairly accepted that was a different basis to the basis on which my clients were being asked to contribute. two questions related to that. Why is it appropriate to have a different methodology for windfall sites compared to allocated sites? Would it not be better to have contributions based on trips generated / impact on infrastructure? And the second question, which is tied in, is he mentioned that some contributions have actually been received from windfall sites, and I'd be interested to understand how those have been specifically calculated, related to trips generated, etc.
There may be this may tie in with agenda item 2.3, which again has been raised before, and I'm conscious that the 6 sites are all different parts of the town and have different relationships with the Junction 3, but have also perhaps similar relationships with the High Street. So Mr McCorriston, if he wants with his planning witnesses to address those issues, and that would address, as I say, issue 2.3 in the agenda as well.
Yeah, indeed, sir. Happy to do so. And you make the point for me, sir, with respect that this is about the likelihood of a property generating traffic on the high street rather than using the slip roads. And firstly, an apology if there's been any confusion in terms of what has been said, but just for clarity, where the windfall site is a housing site, the same contribution rate is applied. So it's the contribution rate which is applied to the site. Apologies, sir. Where it is an industrial site, the contribution will be on a trip generation rate, but the windfall sites thus far have been housing sites, and the same contribution has applied on the basis that a single house is likely to have a car which uses the high street in the same way as the Cala development is likely to have a number of houses which will generate car trips on the high street. So hopefully, sir, that clarifies it, and apologies if there was any confusion in my reference to windfall.
I'm conscious of time. We're moving towards a scheduled time to break for lunch. I was just going to ask a couple of further questions, really, in relation to the repayment obligations. And I know the SG has a brief mention of repayment, but the agreement too, I think, as Barry pointed out earlier on, has provisions at section 9 in relation to repayment. And again, thinking of the fact that this is a 100% contribution, but with potentially windfall sites and industrial sites resulting in the council, in theory at least, getting more than 100%. And I think the response from the council was that that will be repaid in those circumstances. The repayment provisions in the Minerva agreement, I think they might work. And I'd like views both from Mr Alexander and Mr MacLeod as to whether they think they do work. It had struck me that the repayment provisions as drafted look as if they're addressing a slightly different issue. And that is, if you like, just a simple non-use. In other words, you get to the 10 years, the money gets repaid, the contributions are put into an interest-bearing account, and the interest is given back to the developers on repayment. It might work satisfactorily, but I just welcome views. I'll maybe start with Mr Alexander, or if Barry Foy's still on the call, as to whether both the SG provisions, but also clause 9.3, are actually specifically designed to address a scenario where more than 100% of the relevant costs are recovered in order to repay, whether that still works. And after Mr Alexander, I'd welcome Mr MacLeod's view, and in particular, for Mr Alexander, are the council satisfied that this works? The repayment clauses do work in this scenario, and for the appellants, are they satisfied that their position is adequately protected, particularly in relation to interest, that is kind of accrued on a slightly different basis, as opposed to plain interest on the sums that are paid through to the rate of repayment, if those aren't too complicated questions. Mr. Alexander, first of all.
Thank you, sir. I think when you look at the clause, the intention there is if any element or part of the sums aren't used towards the infrastructure requirement, they will be repaid. So the natural step from that would be if the council were to collect more than required to deliver the infrastructure, that excess payment would be repaid to the party who paid it. Now, we've also got additional comfort in terms of the Act and the ability to amend and modify planning obligations by agreement. So it became abundantly clear, Mr. McCorson's example where, instead of 200 units, 400 units go into a site, if it becomes abundantly clear that the per unit figure is going to be skewed, I'm not sure why the council would wait for the 10-year period to elapse to amend the agreement to repay funds they're simply not going to use towards the infrastructure requirements. So I think happily it does work. But I think in reality, I'm not sure why the council would want to hang on to funds that they simply weren't going to use if there was more windfall sites that were going to be payable towards infrastructure.
Mr. Clegg?
I think theoretically that is correct. I think the issue probably is that at this point in time, there may not be certainty about what the actual cost of infrastructure interventions will be. So I think one of the council witnesses indicated earlier on, for example, that in relation to town centre improvements, there weren't specific costs, so it wasn't possible to separate them out and so on. So I suppose one possibility is if you had fixed costs at this point in time, I think Mr. Alexander is quite right. It may not be the intention of the clause, but if you had 10% more houses in Linlithgow than were originally expected to contribute, you could imagine the original 100% of houses paying, if they pay their contributions, not all of their money will be spent because the council's got an additional 10% from those other houses. I think the difficulty is we don't understand that we probably don't have fixed costs for the actual infrastructure interventions themselves. So the money may well just get spent anyway.
Yeah. Okay.
If I may, I suppose all I'd say to that is that's precisely the point, I suppose, isn't it? That as a developer, you have that protection that the level that's been entered into is fixed to that level. It's not going to go up, and there could be other factors that come into play that mean it is more expensive potentially. The council have used the sister report for the basis of the cost, and that's how the per unit figure has been gleaned. But it's not a case where the figure will go up for this particular consent unless the consent was revisited, of course.
Indeed, and my next comment moves into a slightly different area. But one of the issues that we raised in the appeal is that we believe that the infrastructure that the council is looking to put in place at the Western Slips in particular is massively overspec when it comes to the traffic that it will actually cater for. And so there is an issue anyway in the appellant's view about whether the contribution is properly justified in the first place.
Yeah, we'll come to that issue later on. I think it's on the agenda. I'm going to ask just one more question because I think there's only one other issue that's in my mind about paragraph 2.2, 2.3, and then give you all a break. I suppose my question, which comes into focus as well, both in terms of the council's response to paragraph 2.2 given in their hearing statement, but also what we're hearing from today, and it may be we have to continue discussion about this into the afternoon. But I'll pose the question just now, and we can take it up later further if need be. Is how this general approach to the recognised need for infrastructure improvement fits with the provisions of the circular of paragraph 21. And it'll be recalled that paragraph 21 of the circulars indicates that developer contributions are not intended to fund deficits in infrastructure through developer contributions. And it struck me particularly looking at the response to paragraph question 2.2 as to how that worked effectively and the extent to which the council's response sits with paragraph 21 of the circular. I'm looking at my watch and I'm looking at 12:59. I'm inclined probably actually not to get into this particular issue before lunch, but leave it as a question to hang over you all over lunchtime, if you can forgive me for that. But it was that particular point that came to mind, and maybe we can address that if we come back at 2 o'clock, and we could start with that, which was my last question on paragraph 2.2 and 2.3, and then I'd like to go on to a little bit to understand better the differences of the position with the Junction 1B and the Winchborough sites. But if we could come back to that question from Mr. McCorriston or Mr. Alexander, first of all, after lunch at 2 o'clock, if that works okay for parties. Does that sound okay?
Yes, thank you.
Okay, thank you. We'll stop just now.
Thanks very much.
Get some lunch. Thank you.
In 1 month.
Hi, good afternoon. It's about 2 o'clock. So we're all back.
Yeah. Thank you.
I think before lunch we broke with the suggestion that Mr. McCorriskin or his officials addressed the issue specifically in relation to question 2.2 and the Council's response to that under reference to paragraph 21 of the circular.
Yes, thank you, sir. Happy to do that, and as always, colleagues might want to assist with clarification. But the position from the council, sir, is pretty simple. We're not seeking to address an existing deficiency. It's clear that there is a problem with traffic movement in the high street. That's a problem which has existed for a long number of years. Reflecting that previously the town was an area of restraint, the impact of the area of restraint was not specifically to restrict development, but to allow development to proceed only within the capacity of the existing infrastructure. We haven't really moved very far from that position, but we do recognise that some of the constraints have been removed for the reasons which I set out earlier on. So essentially, this is a no net detriment solution which the council is pursuing. You know, when my expectation is that if all 6 house sites are built out and we're successful in securing the motorway junction, Linlithgow High Street isn't suddenly going to move in an unconstrained way. There will continue to be restrictions, and the traffic studies show that. So we're not seeking to resolve an existing problem. We're simply seeking to make sure that the problem doesn't get any worse. If we get some betterment, then all fine and good, but we can't allow the position to get worse. Now, you might say, if that is the case, why is the council allowing development in any case? Which would be a fair question. I think the circumstances in Linlithgow are such, and people like the forum will be able to express this perhaps better than I can, but there is a recognition that because of constraints in the town, constraints on development in the town for a reasonably significant number of years, the town is, for want of a better expression, stagnating. So, there's some indications that the population are starting to fall. It'll be interesting to see what the census says about that. But most significantly, local people are not able to compete effectively in the housing market. Basically, people who are born and bred in the town are being priced out of the housing market through simple supply and demand economics. So one of the advantages of allowing development in the town is that, for example, 25% of the houses will be affordable. So it starts to address some of the wider issues that the area of restraint approach has resulted in the past. So this is about allowing the maximum amount of development that we can without making the situation worse. I mean, it's I suppose a side issue to the overall consideration, but just for context, sir, the reason that it's around 6 sites or 9 sites, whatever table you look at, that is being facilitated in the town, is that's because that's the remaining capacity, that's the capacity that has been freed up in the secondary school through the building of the new Winchborough Academy. So we will pretty quickly hit another education constraint within the town, but what we're trying to do is take us up to that education constraint, allowing sufficient housing to do that, to bring a bit of vitality to the town, but in doing so, not making the situation in the high street any worse than it is at the moment. So, sir, appreciate it's a long answer.
That's okay.
But the key point is, this is not about, it's about managing the high street. It's not about putting a motorway junction in that removes all of the congestion in the high street. That's not the intention, and that's not what the studies show will happen.
Thank you. I'll make an observation. I'll bring in Mr. Alexander first of all before I go to Mr. MacLeod as a response to that. I don't know if Mr. Alexander has anything further to add from the legal perspective.
No, thank you, sir. I think Craig gave a useful summary there, and I can no doubt come in with further points if required.
Yeah. My observation before I go to Mr. MacLeod, from what I'm hearing and read in terms of the development of the LDP, I hesitate, and I don't want to use the word unique, because no place is unique, but nevertheless, it does strike me that there are recognised difficulties and challenges that have grown up over the years in relation to Linlithgow. We'll talk a little bit in a while as to how long that issue has been brewing. But it does strike me as an observation, and Mr. MacLeod will have a view on this as well, is that the solutions that have been adopted by the council are to a degree a recognition of the unusual history and circumstances that have developed. As I say, no place is unique, but I do get a sense, both from today but also from the papers I've read, that there is a response to a particular problem in a historic town with a high street that has had air quality issues in the past. We'll come to the evidence of that shortly. But there's a sense I have that the solution the council are seeking to adopt, and it requires to meet the tests, is one that relates to the peculiar or specific circumstances of Linlithgow. So I put that observation before bringing in Mr. MacLeod, either to answer the points that have been made, answer the specific question about the interrelationship between the council's position in paragraph 21, or even any thoughts from him or Mr. Snedden on my sense that I've expressed just now. Thank you.
Thanks, sir. Yeah, probably 3 observations, I think, from me, and then I'll hand over to Mr. Snedden, who's got a couple of detailed points that you'll want to be aware of. So the first is, and this is in the submission that we've given you already, the first is that there is clearly that the reason that the slips first came into being, or the concept of the slips first came into being, relates to a very historic development, Sun Microsystems, and has nothing to do with the housing development that's now proposed in Linlithgow. The second point concerns the focus on the town centre, and it seems fairly clear from the position that the council's now taken at this appeal that the reason that they are focusing on the slips is because of the town centre and perceived problems specifically related to air quality. And two points on that. The first is that the supplementary guidance that the council approved, paragraph 5.48, says this: traffic levels through the town are below saturation levels. However, additional factors regarding inappropriate parking, loading and unloading to businesses and buses stopping, creating tailbacks, are not helping vehicle movement. So those are issues concerning traffic management rather than volume of traffic. And then the third observation, which may well be linked to how much traffic there is now, is that you'll recall, sir, that we lodged a screenshot from the council's website related to the Linlithgow air quality management area. And it explains the history that in 2016, an AQME was designated for the whole of Linlithgow, not just the high street where the measurement took place. And I'll have more to say about that in due course. It was designated for the whole of Linlithgow because of breaches of the NO2 and PM10 criteria. What the website tells us is that in the last 3 years, air pollution levels have met air quality objectives, and that a detailed assessment is being carried out to assess whether Linlithgow AQME should remain in place, and that if it remains in place, the air quality action programme will then be finalised. The point with that is, if during the last 3 years, air pollution levels have met air quality objectives, it suggests that since the time the council prepared its supplementary guidance, things have got better within the town centre, and that there may well not be the need for the measures that the council previously thought. Now, I'm going to hand over to Mr. Snedden, who's going to tell you about what the effect of the measures the council is proposing would actually have on the town centre, and this is quite an interesting point, I think.
Thank you. Thank you, so, sir, I've been looking at paragraph 5.8.2 of document A015. That's the system model report. Just give you a moment to take that out.
Yeah.
And for completeness, I'll just read what it says. It's only 4 lines. So it says table 10, which is the morning period, and table 11, which is the evening period, show the results for each journey time route for each scenario. And in the report above this paragraph, there's a picture of the journey time routes. And the tables are presented as the change of each result from the equivalent base model result. Results are colour coded so that red equals worse, yellow equals no change, and green equals better. So if you then turn to tables 10 and 11, which are on pages 32 and 33, and the line of interest is the second line from the bottom of the table, which says total. So what that's doing is summarising the journey times through the network. You can see on table 10, if you read along that line, that all the percentages are red, meaning worse.
Yeah.
And the table in the table on page 33, the first result, which is 0%, is green. In the previous table, there's a 0% that's red. And along that line, there's only 2 results which are green, minus 2% under test 8A, minus 2% also under test 8A. But they both are tests where the Bowness traffic has been removed, and that's a highlight of the model, well, maybe a low light of the model, is that Bowness traffic just mysteriously disappears in some of these tests, although in reality, clearly it wouldn't. So if Mr. McCordston is interested in no net detriment, then my reading of that paragraph in these 2 tables is that all the scenarios cause detriment.
Just bear this for a second. Thank you. Now, I was going to ask Mr. Carmichael, first of all, to come in and talk about the point made with Mr. MacLeod about the air quality. levelling out or potentially improving, and then ask one of the transport witnesses maybe to respond to Mr. Snedden's point just made. Mr. Michael first.
Thank you, sir. I think obviously reference made to the council's web page on the only data that was available there in 2016-17. In fact, all the data and all the reports up until 2023 this year is on the air pollution website, and I'm talking about the up-to-date situation. Linlithgow air quality for the objectives have continuously sort of declined and levelled out, which is why we're in the position of looking to revoke air quality management areas currently due to the historic compliance with the objective levels under the air quality objectives.
Are you saying then that information that's been suggested on behalf of the appellants is not representative, or is no longer representative? Just make clear.
I think the conclusion is probably the same, but it's in that Linlithgow air quality has declined relatively since we declared it as an air quality management area. There's been a continual decline over the years since 2017. There was obviously some changes within that, where the air quality equipment was changed within the location of the high street to a different site. But fundamentally, there's been a decline, and that conclusion that's obvious by the appellants based on a couple of documentations that they've seen referring to 2016-2017, the conclusion is relatively the same, even though a detailed assessment was undertaken in 2016 to suggest that there's a high risk of the objective being exceeded within the high street of Linlithgow.
Where would I see this evidence? Because obviously the screenshots has been mentioned there by Mr. McLeod.
You would see on the air pollution page, I think Mr. McLeod's obviously picked on the tab that says Linlithgow air quality management area, but all the documentation for annual progress reports and the updated detailed assessments for Linlithgow are contained, at the bottom of the page that obviously Mr. McLeod was referring to.
Yeah, it'd be useful to give me a reference to that so I can find it. I'm not going to spend any time here digging through documents that may be quite hard to find. Obviously, I've seen I see the reference that's been made to that document, but if you were able to identify, ideally at some point before the end of the hearing, or even just by email, where I should look, and ideally as soon as you can, to give Mr. McLeod an opportunity to be aware of that evidence that you're pointing to.
Certainly, I'll provide a web link to that air pollution page on the council's website.
Mr. McLeod?
I have to say, sir, I do have an issue with this, because the appellant's position on air quality has been well known since the response that we put into the council's response on the appeal. You then asked very detailed questions in relation to air quality, and the council declined to answer them. The council made a general statement about air quality, but what Mr. Carmichael now seems to be suggesting is that there is other evidence that the council has that has not been disclosed despite your request for evidence on the issue, and we have not seen that evidence. Now, it leads on to a further question, which is, if air quality is so dire in Linlithgow, why on earth has the council taken so long to approve its air quality action programme? And that's an issue for later in the agenda. But just to be absolutely clear, is Mr. Carmichael saying that air quality has declined in the sense of air quality has got worse? And is he saying that the council's website is inaccurate? Because it makes it quite clear that there have been no exceedances for the last 3 years.
So if I could come in on that point, maybe a bit of maybe I wasn't quite clear enough when I'm talking about decline, a decline in relation to the objective level, which means air quality has actually improved over the years. I'm referring to the decline in the sort of trend lines relative to the air quality objective. So that in effect that our trend line is coming down, therefore air quality is improving over the years since the air quality management area was declared. So Mr. McLeod's right, it's just I've described it in a different way when I'm looking at trend lines. So there's been an improvement in air quality since 2016-17.
So has been an improvement.
Yes.
And your position is that improvement is caused by what?
There could be a number of factors. I mean, the main source of air pollution in Lithgow is traffic, and obviously over that number of years, we have had cleaner engine technology in new cars, electric vehicles. So there'll be cleaner technologies, less pollutant, particularly diesel vehicles. So this has all contributed to that decline, as the majority of air pollution is caused by vehicle traffic through the high street.
And so in terms of the ongoing necessity for these contributions towards the measures, what's the council's position in terms of the frequency in which that indeed has been reviewed, or is being reviewed, or is due to be reviewed?
Well, currently the Air Quality Action Plan, which was developed in 2017, was still in draft, still is in draft, for probably various reasons. That hasn't moved forward as quick as we would have liked to have moved forward, but things have overtaken that. That action plan in relation to the current air quality emissions in Linlithgow. So the current air quality action plans did not move forward, although recognised a number of areas that may contribute to decreasing traffic in the Linlithgow High Street. So it's there was no move forward to contributing or allocating expense towards the different measures that the action plan came up with to try and improve air quality.
How can the council be sure that the improvements that are related to the junctions at the Lowport, Eastport and Westport, how can council be satisfied that those improvements are still needed, given the changing situation, but the non-finalisation of the Air Quality Action Plan?
Well, I think any improvement in vehicle movement in the high street is perhaps it's not been directly modelled for air quality, but any reduction in traffic emissions or any improvement in vehicle movement through the high street, avoiding less congestion, will be an improvement on quality pollution.
Okay, Mr. McLeod. Anything further on this point?
Just one point, I think, but thank you, Mr. Carmichael. That's helpful clarity, so that there have been further improvements rather than declines. One of the points that Mr. Carmichael made as a potential reason for those improvements was changing technology, and it's perhaps relevant to note that this development has, I think, an EV charging point for every property. Beyond that, I don't think I have anything else I need to say at this stage, sir.
Okay, yeah, that's fine. And can I bring in one or other of the transport witnesses from the council to respond to the points made under reference to the SISTRA tables that refer to the air quality improvements?
Apologies, could we ask for Mr. Snedden to repeat the question again?
Yeah, sure.
We've got the tables in front of us.
Yeah.
Thanks, Victoria. So the tables are tables 10 and 11, and they're on pages 32 and 33 of the SISTRA report, just to be clear. and they link to paragraph 5.8.2, which is on page 29. And there they say results are colour coded so that red equals worse, etc. And in the total row of each table, which is the second last row on each table, you can see in the AM table there, all of the percentages are red. And in the PM table, there's 3 green, but one of them is 0%, so no change. And the 2 that are green, that show some improvement, which is only a 2% improvement, are related to scenarios where Bowness traffic has been removed from the network. So, I didn't really have a question about that. I was really just drawing attention to it.
I suppose the question might be, does the council agree that that is what those tables show, namely that the introduction of the slip roads will result in a worsening of traffic conditions? If I can put it that way.
No, we wouldn't agree with that.
On what basis?
It's on the basis that, as you've said, the Bowness traffic's been mitigated, and it makes it slightly more difficult because I think Steve would be able to tell us. Steve, could you tell us why that was mitigated in the first instance?
Yeah, the situation in Bowness, which is obviously in Falkirk Council area, the Falkirk Local Development Plan did not make any demands on developers in Falkirk to make contributions towards the M9 slips. However, the Falkirk LDP does reserve land on the north side of the M9, which is really the parallel to where the proposed slips would be in Linlithgow. So they've reserved land for that, one of their policies. They're not actually requiring developers to make any contributions because they didn't conclude that development in Bowness would have that much demand.
And the Bowness, is that within West Lothian or Falkirk?
No, Bowness is in Falkirk district.
Falkirk, right, okay. Is there anything further on this point?
Yeah, my immediate thought there was that Cala should probably have gone and built in Bowness then. It seems that they wouldn't have been hit for any obligations towards slip roads, and all of their traffic would have just disappeared as if by magic, because what happened in these modelled scenarios that without Bowness is that Bowness traffic has just been magicked away. In reality, that traffic does not disappear.
I think that's the point that just one very brief point. When Ms. Mungle mentioned the fact that the Bowness traffic had been mitigated, it hasn't been mitigated, it's simply been removed from the model as one of the modelling scenarios. So I suppose the question for the council is, does the council believe that there is any traffic from Bowness or not that would use the town centre?
The only thing that I would say in that is under section 2.1.6 of the SISTRA report, the assumption's been made that all trips which currently go from the east of Linlithgow to the west will now use the western slips, and that's illustrated in figure 1.
That's partly true, but if you look at page 11, which is the representation of the traffic model network, I expect we'll want to come back to this at some point, then just let Victoria catch up with that page.
Thank you.
See when you've got that, Victoria, page 11, it's the picture of the model.
That's me, yeah.
Okay, so if you look at zones 41 and 42, that's St Ninian's Road. And St Ninian's Road joins the High Street at zone 35. So the effect of that is that if you take Bowness traffic out of the model, that node 35, which is one of the three that the council highlight as being specifically problematic, no longer has Bowness traffic going through it. So it doesn't really matter what happens at the route 3 to 1. If you take the Bowness traffic out, you improve the situation in the high street. I mean, there's no real surprise in that, I think. If you take traffic out of a model, then you might expect it to be better. Despite what the tables say.
Do you want to comment on that?
Well, sir, if you would indulge me, I've got a few comments to make just on the
Yes, Chris.
The last representations there, and I'll start with Mr. Sneddon's comments that perhaps Cala should have built in Bowness. Well, of course, they were entirely entitled to do so if they could have found a site, but they didn't. They chose a site in Linlithgow, sought planning consent for that site, obtained planning consent for it on the basis that they considered the contributions were justified, and would seek to persuade the landowner likewise. And of course, so there's a letter to that effect before yourself. In terms of moving back to the starting point of your question, really, sir, which was about, is there an existing problem? So helpfully, I've now got access to the LDP examination report, which I couldn't find earlier on because of connection difficulties. But in there, and the reference, sir, is in essentially page 176, which is the section on Linlithgow transportation arrangements. The council sets out, this paragraph 6 on page 176, the council sets out that it is pursuing a no-net detriment approach to development in Linlithgow, and the reporter then accepts that position and makes no changes to the position with respect to those interventions. So I just wanted to be absolutely clear that from day one in all of this, the council's position has been no net detriment. So we're not trying to resolve a difficulty. Cala's development, because they have chosen to build in Linlithgow, has a detriment or will result in a detriment. So the position remains a detriment on the high street. So the position remains that as per the development plan, they should be obliged to make a contribution. Excuse me, sir. Coming to the further representations from Mr. Sneddon, I have to say I didn't fully understand the points that were being made, but I think it might be helpful, sir, to explain the relationship between Bowness and Linlithgow.
Yeah.
So if you are a resident on one of the new sites in Bowness and you're travelling east towards Edinburgh, then you will use the existing slip roads. If you were travelling west, you might use the new slip roads if they were provided, the westbound slips, or alternatively, you might continue to use the existing route through Bowness itself, which is a reasonably good route, and access the M9 further to the west. But the key point in all of this is that, and we keep saying it from the council's perspective, the issue is, what is the impact on the high street? Not necessarily who's going to use the motorway junctions, what is the impact on the high street? So will the residents of the sites in Bowness be likely to use or traverse the high street in Linlithgow? I would say that they are less likely to do so. The reasons that they would go there might be to access the railway station, because the Linlithgow railway station will be the closest railway station to the sites in Bowness. They might utilise some of the recreational facilities, pub, restaurants, etc. in Linlithgow High Street, but they wouldn't have any real reason for commuting purposes, etc., to come along Linlithgow High Street. So that's why we have looked at scenarios where they are taken out of the equation, because the question is, will they add to congestion in Linlithgow High Street? Because that is the problem that has to be addressed. So hopefully that gives you a bit of a background and explanation as to why the scenarios with the Bowness development's been taken out. Thank you.
Just on that, just taking the flip side of that, Bowness is at one side of the town. You're looking at one of your 6 identified sites at Kettleston Mains, which is the other end of the high street, and presumably, if you're going from Kettleston Mains, if it was given permission and developed to Falkirk or Stirling, right now you'd got on at Lathallen. You go into the town, it's the only option to use. What would be the position if the west-facing slips were built? Would it be the case that it's more likely that Kettleston Mains traffic would also still use Lathallen and wouldn't go all the way through the town onto the new Junction 3 and head west?
Yeah, I think that's a reasonable assumption, sir. However, it comes back to the same position that the council has set out on a number of occasions now. Would that traffic access the high street for other purposes? So if that traffic was going east, would it go to Lathallen and then double back? I think that is unlikely because of the significant increase in distance in doing so. So the traffic from that development would still place pressure on the high street in Linlithgow, which is the issue which we're seeking to resolve.
Yeah. Presumably then, if you're looking at places like Springfield and Wilcox Home Farm and Pilgrim's Hill, if that's granted, presumably they would also, if they wanted to go to Stirling, traffic would not normally go through the high street. It would go on at the new slips, presumably. So I guess there might be a difference. If your point is it's the emphasis on the high street that matters, the high street is your position that the high street would become quieter, less used, less polluted, and that would benefit Deanburn Road and the other sites. Is that what you're saying?
Well, that's exactly the council's position, sir. It is only through removal of traffic from principally the east of the town that creates the capacity to allow new traffic into the town on a no net detriment basis.
It's almost Nicol had his hand up at one point. Does he want to come in at this point before I go back to Mr. Snedden?
Yes, good afternoon. I was just answering for Mr. Snedden's question about the Bowness traffic on St. Ninians Road. The modelling that was carried out was for the new developments in Bowness as contained within Falkirk's local development plan. That's what was initially to be included, and then as been said already from Craig, from Mr. McCorston, and Mr. Lovell, that Bowness traffic was taken out because Falkirk weren't interested in including it. So what happened was that the modelling that was carried out, this paper was based on, as we've already said, and let's say it again, it was based on the volume of traffic through the town centre, and that so the developments as at Kettleston Mains and all that was added in by the reporter had traffic coming through the town along the high streets, such that St. Ninians Road junction, the existing traffic that was in the modelling coming out of St. Ninians Road was unable to get out onto the high street due to volume of traffic from the developments, from all collectively from the whole developments within the 6 sites, and so that became an issue, and that's why there has to be that junction is included as one of the improvement junctions to be looked at. It's because of the increase, the collective cumulative impact of the number of trips from all the development sites that would go for traffic trips that would aimed along the high street from whichever direction that they were in. So the Bowness traffic, the existing Bowness traffic, that uses St Ninians Road, was in the modelling, continues to use the model, and the model was the model that was used for the CES Tran for the CES plan modelling at high level above the local plan South East Scotland network. So it was whatever it was, the trips that was already in that was in the modelling, and that there was no new trips added on to St Ninians Road as a result of any developments.
I'll invite Mr. Snedden to come back in, and I know that he'll want to say anything further just now, but I'm just trying to get my head around which of a number of strands of concern are arising from the appellants as to whether it is the level of overuse of the high street, the saturation levels have never reached the point of being significant enough to justify action, or whether the situation is improving over time because of other measures, or whether it is that we don't know what the current position is because of the evidence that's been collated by the council is out of date. And it could be more than one of those. They're the 3 strands that I'm taking effectively from, in brief, and Mr. Snedden can correct me if I've got any of that expression of it wrong, but they're sort of 3 of the strands of things that you're saying. There may be more, but maybe fair summaries as your various lines of attack.
Well, I think, sir, Mr. Nicholl, I think, stumbled across the truth there in what he said, and that is that the Bowness traffic was taken out because Falkirk weren't interested in levying developer contributions. That's the nub of it. If the west facing slips were built with Bowness traffic, some Bowness traffic would use it. But other Bowness traffic would, as Mr. McAllister indicated, continue to use Linlithgow High Street. And particularly having in mind the Kinglass Farm development in Bowness, which is an easy route into Linlithgow via the route that I mentioned to Victoria earlier, down Node 41 on page 11 of the sister report. And without wishing to flog a dead horse on this particular point, so then if you look at page 11 on that report, and this particular issue about the St Ninians Road junction, which is Node 35.
Oh yes.
Then if you look, sir, at zones 41 and 43, so in the kind of top left picture.
Oh yes.
Right, they are joined by a road. So in a true model that doesn't have a closed loop in it, which this model does, if the congestion gets too bad at zone 35, an alternative route in reality exists, and that is 41 to 43, and then to the Mill Road crossroads, just to the right of points 1 and 2 that you can see on the plan there. But in this model, that traffic doesn't have that option. It's always going to pile into 35, and the queue is going to get longer and longer because the option for that route choice isn't in the model. And when we talk about Mr. McCorriston's comments on the removal of the Bowness traffic, which I think, in fairness, Craig, you tried to kind of downplay a little bit. If you look at page 10 of the report, there's a table there, table 7, and the matrix totals refer to the total amount of traffic movements through the model. Now, in the AM, in the 4th row down, With the full development demand, that number is 6,284 movements.
Yeah.
When you take Bowness out, it's 5,557. So that's 727 trips that have been removed from the model. And the corresponding number in the lower half of the table is 688. Now, these are not insignificant numbers.
I think then, sir, if you managed to digest that information.
Yeah, absolutely. Thank you. Yeah.
Back to your point about what are the appellant's lines of attack here. I suppose the first point, and this has been out there for a long time, is that the council's own evidence when they were producing the supplementary guidance said that there was not really traffic capacity issue within the town centre. What the council said is that traffic levels were below saturation levels, but there were traffic management factors that needed to be addressed in order to make things better. That then goes to the reasonableness of the mitigation solution, which is a multi-million-pound motorway junction, which, as Mr. Snedden has just shown, actually makes things worse within the town centre on the council's own evidence. The second point is that, and we can only really focus on the evidence that's before this hearing. The second point is that whilst the council may have thought it had a justification to require mitigation for air quality reasons at a point in time, back in 2016 when it declared an AQMA, the evidence for this hearing is that since that point in time, air quality has got better on an annual basis, and that the position is now much less worse than it was at the time the council dreamt up its idea for supplementary guidance to deliver this mitigation. So those are probably the two primary lines of attack that, as you described them, in relation to these points. There are others which we will come on to later on, but that maybe summarises our position on these issues, I think.
I mean, the reason I posed the first question in that way is that there's a thought in my mind that if it's the proposition that the council have got to wait until saturation levels been reached before they're entitled to take action, that feels kind of intuitively wrong, that they can't take preemptive action. And I'm not saying that's how it's been categorised by the council, but the point about it, the levels hadn't reached saturation level, is it your proposition that it needs to reach saturation level before the council are entitled to take air quality measures?
Absolutely not, sir. The point is that the council's evidence is that there was a problem, and I emphasise there was a problem, but that problem was not to do an air quality problem. That problem was not to do with the level of traffic. That problem was to do with the way that traffic was moving through the town centre. Now, the council produced an air quality action programme in draft in 2016 or 17. So that's best case scenario 6 years ago. That has never been taken forward. The air quality action programme contains a whole range of measures, and we can maybe look at them later on, but contains a whole load of potential measures that might make things better from an air quality point of view. The council has never looked to implement any of them. And the reason the council has not done that is because, as Mr. Carmichael indicated, the council is currently considering revoking the air quality management area because the evidence shows that there is not an air quality issue that needs to be addressed.
Okay. Now, Mr. Alexander, I don't know if you want to come in or bring in any other kind of representations based on what you've heard. We could go round the house again in asking for further comments, but I think we probably have a sense of where the difference between the parties are. So from your perspective on behalf of the council, how would you draw this together from your sense of this issue?
Thank you, sir. I suppose I would take a straightforward approach to this, in that we know that the area of restraint was removed and we have 9 new sites. So we know, if all comes to pass, we'll have 624 residential units in the area in Linlithgow. And we know that the High Street is a problem area in terms of traffic volumes, traffic speeds, and because of that, resultant air quality. So in my mind, it's quite clear that the council need to do something in terms of tackling those issues on the High Street. And what the council have put forward in accordance with the LDP action programme and the sister report is a package of measures to ensure that traffic flows on the High Street can be adequately mitigated to allow these new developments to come forward. Now that's a very straightforward approach to it, and others may want to add to it, but that to me is the nub of it. We have a number of new units coming forward, we know that, and we need to plan accordingly for that. We have obviously, as you alluded to, Linlithgow is perhaps a bit more different to some other areas, and we need to get the solution right to encourage new development in the area for the reasons outlined by Mr McCorriston earlier.
Okay, and Mr McCorriston wants to comment, and then I'll bring in Mr McLeod again. Both of them have their hands up. Mr McCorriston first.
Yeah, thank you, sir. And I don't have much to add to what Mr Alexander said there, but part of my role as the planning officer for the area, the council's chief planning officer, is to reflect on, at least in as best as we can within legal provisions, the aspirations and expectations of the communities which we serve, and certainly the forum may have something to say to this. But sir, I would simply draw your attention to the submissions which the council made, which are the responses to the Linlithgow Planning Forum's consultation, and particularly the very high level of support in that document. I accept it's a 2015 document. I believe there is a later document which has very similar results, but I didn't have a copy of that. But you know, what are the figures in there? 90, give me just a second. 97% of respondents.
Sorry, Mr McCorriston, I missed your document reference there.
Yeah, so sorry. Hopefully colleagues will be able to assist me with the reference. It was one of the later documents submitted by the council. It was one of 3 that was submitted.
Yeah.
And it's the questionnaire responses. Yeah. Apologies that for the reasons I explained earlier, I don't have those references to give you, but hopefully you found that. And it's simply setting out that, you know, of everything that the community in Linlithgow were asked about, the second highest response, I think, was to deal with high street air pollution, topped only by those who wanted the issue with loch and watercourse pollution dealt with, but 97% of respondents saying that addressing pollution in the high street was an issue. And while, sir, you've got that document in front of you, it might worth also be also be making reference to section 5 of that questionnaire. And it's question 5B, which relates to the 4-way motorway junction, of which 87.67% of the respondents agreed that that was something that the council should be, well, the public authorities should be pursuing in terms of solutions to the town. So again, you know, I know that's not about compliance with legislation, but it's reflective of what's put into the local development plan and indicative of an up-to-date view of the community of Linlithgow about what the public authorities should be addressing. Thank you, sir.
Yeah. And I do want to bring in the planning forum on that point, but I'm actually going to move on to the next bullet point. I want to go back to that survey because I want to ask the planning forum in particular some questions around that. But Mr McLeod, first of all.
Just two very brief points. One in relation to that document. as Mr. McCorson says, it is from 2015. It predates both the designation of the AQMA and the subsequent evidence that shows the AQMA is no longer necessary. And then the second point was when Mr. Alexander was giving the sort of the higher level overview of the benefits and so on. The detailed evidence that Mr. Snedden has given this afternoon is that actually the council's solution would make traffic in the high street worse. Journey times would increase by significant margins in quite a few scenarios. So it's not a case of no net detriment, which is where this line of discussion came up. It's not a case of no net detriment. The council's position would have potentially significant detriment on the high street, albeit that the high street is in a better place now from an air quality perspective than it was at the time of that survey.
Thank you. Right. I'll move on to item 2.4, which to a certain extent will link in the 2.7 on the agenda, and beginning to get into the question of the issue of the justification for the full extent. If the general justification for contributions is shown to be established, the fact that it's the full costs, that's the issue arising here. And the reason I specifically wanted to mention Junction 1B at Winchborough, not that terribly long open now, and Mr. MacLeod has pointed out there are differences in the LDP background in the context of that, is that thinking about the justification of the percentage contribution, one of the differences that has struck me, and I raise this in case I've got the wrong end of the stick and somebody wants to correct me about all of this, is that the circumstances in Winchborough seem to be ones where there's been a very, very significant amount, I don't know the exact number, but a reasonably significant amount of new housing development, and the need for Junction 1B has arisen because of that need. And while obviously others will use the junction, it's not only for users or visitors to the newly consented sites. Nevertheless, it's very much the case that it seems to me that these were junction improvements that had a very direct correlation to the significant amount of housing development that was there, and that justifies and would justify a 100% contribution. The question that is in my mind is, to what extent is that the case for the Lithgow? I would tend to categorise as a kind of tipping point argument, that where the needs become so great, you tip over, and rather than the development, this site is one of a range of sites contributing to the need for the infrastructure improvements. It seems to me, and you'll correct me if I'm wrong, from the council perspective, at Winchborough, the need for the junction was created by the need for extra housing. Now, one way of looking at the council's argument is the need for the town centre improvements and the west-facing slips is created by these sites because that's the tipping point. I want to understand, is that what the council are saying? Is that how their argument runs by analogy to Winchborough? And if so, the question is that a fair analogy? Is this effectively a tipping point argument? None of this would be happening if it wasn't for this development being approved and the other developments being approved. Or are they arguments related to other ways of looking at the problems? And Ms. McCorson may be the best person to start us with this.
Thank you, sir. I'll be happy to do that. And I think the simple answer is yes, you are correct. It is a tipping point argument. It's the tipping point in relation to the impact on the high street, as we keep saying, and the solution to that is the motorway junction. As a planning forum have said earlier on, that there are potentially other solutions, but this is the solution that is deliverable and fundable in the council's view in the shortest period of time. There was a tipping point argument at Winchborough, so it's exactly the same. There are 3,450 houses as part of the master plan. There's actually a few more than that because a few windfall sites have been consented since. But the master plan is for 3,450 houses. The tipping point, as you describe it, for the motorway junction came at 1,000 houses. So the transportation assessments said that traffic in and around Winchborough did not work without the motorway junction at the 1,000 occupation. So essentially there was a Section 75 agreement with an obligation in there that obligated the developer to fully fund and deliver the motorway junction by the 1,001st occupation on the site.
Okay. That's very useful, and that leads me into a number of questions, one of which has been touched on already, the Sun Microsystems. What I'm interested in is a potential difference between Winchborough, because obviously the development of permission for these 3,400 odd sites has come within a relatively short period, hence creating the tipping point. But there seems to be quite a lot of information, and it'd be useful to get chapter and verse on this. The need for at least west-facing slips at Lithgow has existed for some time. I noted it was in the 2009 local development plan. There was a policy there. I think somebody's referred to that. I've now lost track of who made the point. Somebody's made the point. It was recognised as long ago as 2009 LDP in Policy Tran 29. It would be useful to know when Sun Microsystems came into the town. Useful from that point of view. And I want to bring in the planning forum before I ask Mr. MacLeod to respond to this, because I too had picked up the information from the 2015 survey. I'd actually drew something slightly different from it, from what was mentioned a moment ago, and the bits of that I was looking at was a recognition there. Actually, Mr. McCarson has mentioned one of the points I noted as well, that even as long ago as 2015, there seemed to be a desire represented in the survey, and some of the individual comments, which are only individual comments by people who made comments on that, nevertheless indicated that the need for the various improvements has been a long-standing part of the psyche, if you like, of Lithgow. So it seemed to me that matters have been there for a while, but maybe the planning forum might be best placed to speak about what the people of Lithgow, insofar as they collectively speak with one voice, what their view has been about the need for air quality improvements and the need for the west-facing slips, since when, and is it indeed a strongly held view amongst the people of the town?
Okay, yes, thank you. The evidence from Sun Microsystems, I'm afraid, is only colloquial. I've been trying to dig back into the past history. We're talking about the 1980s, when the Sun Microsystem factory was first mooted, and having recently moved to the town at that point, I was very aware of the discussion that was going around saying, if Linlithgow accepts the Sun Microsystems factory, then it will get part of it will get the west-facing slips. So it was certainly in the conversation at that point in time. This was a Scottish Office project, of course, well before evolution. And to my mind, the west-facing slips have been there ever since in background, so it's no surprise that it did occur in the 2009, and I think possibly in the previous Linlithgow local area plan that preceded it. But there's I can't put my hand on evidence that the Scottish Office promised the west-facing slips. survey which has been referred to and which the council submitted as a document has been updated. The survey was rerun actually by two organisations, both the Planning Forum and St Michael's Parish Church, together with the Linlithgow Community Development Trust, also ran a separate survey, which I would call the community survey to distinguish it. So the community survey was an open survey, just asked questions like, what do you like best about living in Linlithgow and what do you think are the problems? And they were good enough to give me all of their raw data, which I was able then to process. The numbers who mentioned the high street as a problem first was about 35% of the total response, which in the context of an open survey is just an unbelievable result. It does show that if 35% of people from an open survey, and we're talking about 240 responses or thereabouts, recognise that as being the primary problem, then it's got to be believed that it is the primary problem. The Planning Forum ran its own survey last year as well, finished in December, and that too reinforced, in fact, the figures. The figures in favour of the west-facing slips had gone up to 100%, but the problems of the high street were there in the upper 80%. That people recognised that was a problem. I think most people accept that whilst there could be improvements in traffic management, picking up Mr. McLeod's point, the major problem of Linlithgow High Street is the fact that it is a main through route, it is a distributor road, and it is a residential street, and it's trying to perform every single function. And that constrained by two very low bridges, which prevent sort of double-decker buses. We have 6 bus routes through the town, and we have we have 1 bus lay-by. So it's not surprising that traffic builds up behind buses. Parking is an additional problem. We have very little in the way of double yellow lines down the high street, and people do tend to take advantage of the parking on the pavement and indiscriminate parking elsewhere in the high street, which also congests traffic. So I would accept from that point of view there is a management improvement, but you can't get away from the basic fact that the high street is trying to perform too many functions. So anything, we talk about tipping points, I think we're already there, to be perfectly honest, that any more development is the straw that's going to break the camel's back without a different resolution. I mean, we need a different solution, of which the west-facing slips is one element. But it's not a simple question. I'd also say that the Sistra report is based on a mathematical model, so in that sense it can't input things like the bus stops and the delivery trucks and the indiscriminate parking, which is a feature of the high street. So the Sistra report, I think, paints a picture which is actually better than it is. So those are my comments on that. I would be able to circulate the latest data from the surveys, but the analysis was only completed at the weekend. Thank you.
From my perspective, what I'm interested in for this part of the discussion is the fact that it's 2015 data. So it's the fact that it's older data. If others would think there's a benefit in me seeing more up to date data, then you can no doubt say. But on the issue generally, I'll bring in Mr. McLeod now.
Thank you, sir. Maybe
it starts with Winchborough, you recall.
Indeed, yeah. And I was going to take us back to Winchborough and look at things in a slightly different way. So what you've talked about is the tipping point and the need for infrastructure to deal with an impact. And I suppose in a way that is what we're here to discuss today. It's what that infrastructure is, whether the impact from the development justifies that infrastructure and so on. But take Winchborough as a general example. A very big development, a very big piece of road infrastructure required to serve it. In this case, we have an existing town, we have some new developments, and we have a very big piece of infrastructure which the local authority is asking the few developments that are coming forward to fully fund. Now, one of the issues that we raised in the appeal statement, and it's paragraphs, it starts at paragraph 6.3 under the heading, the infrastructure is selected, and that leads down to 6.10. That passage of the appeal statement deals with the question of whether the western-facing slip roads are really what is required in this case. And one of the points that was made, and you'll find this in paragraph 6.9, is that the junction design that the council is proposing could accommodate traffic volumes of almost 13 times the modelled volume of traffic in this case. Now, the council has never answered that point. So let's take a hypothetical scenario where there is a need for some form of slip road to go on to the M9 to alleviate traffic issues. The evidence does not suggest it's this slip road or these slip roads at the cost that's being proposed by the council. The evidence suggests that if mitigation is required, it's likely to be at a far lower standard than the standard that the council has proposed. And that evidence has never been challenged by the council.
I'm going to try to maintain some discipline on my agenda, and we'll come to that point under paragraph 2.14. The questions arising from that. I understand the point you're making. We'll come back to that when we get to that stage of the agenda.
So I suppose just to take it back to your question about the tipping point, yes, we can readily understand why a tipping point was reached at Winchborough. The current evidence suggests that the tipping point in Linlithgow has not been reached, and then separate to that, and that's the point about air quality improvements and so on. And then the subsequent point that, as you say, we'll come back to is, even if it has been reached, what is the requirement? Is it a Winchborough scale solution, or is it something much lower? And we suggest it's something much lower.
I just wanted to add one thing to what Ian has just said, sir, and it goes back to a comment that was made by Dr. Kelly. The model isn't strictly mathematical, it's deterministic. So a much cleverer person than me wrote the software for dynamics. And it's based on driver behaviour, essentially, what drivers do in certain situations. And it means that the suite of modelling is capable of modelling things in, like bus stops or vehicles stopping in the carriageway. So you could give it a bus timetable, for example, and it'll assume that the bus is going to call at certain stops. So it is possible to model these effects in. I can't tell you whether that was done.
there's a degree to which these things can be modelled, but again, as with much of this stuff, it's not a completely exact science in looking at the modelling. After all, at the end of the day, what you're modelling is traffic coming from a site that's not been built, using a road that's not been built. So there's a degree to which the modelling has to be given a latitude and a degree to which it can't be viewed. It may be the best information that's available, but it can't claim, obviously, to have complete scientific precision. One other comment, I'll bring in Mr. McCormick in a second, is I took from Dr. Kelly's evidence just a moment ago, is my sense was, maybe I picked this up wrongly, not so much that the tipping point has not yet been reached, but that the tipping point was reached some time ago, I think is what I was taking him from saying. But I'll bring in Mr. McCormick on this issue. His hand's up just now.
I think Mr. Sten had one
Finish with Sten's point and then we'll go to you.
Yeah, I was just your characterisation of model, sir, and in relation to roads that don't exist. I mean, the general purpose of modelling is to model roads that don't exist, to find out how they're going to perform. And in this case, they include roads that don't exist because they include west-facing slopes.
And I'll just add one final point, which is the other problem, or the problem, or one of the problems with this model is it doesn't include roads. Sorry, it doesn't include roads that do exist. As Mr. Snedden explained, the model cuts off at certain points, so it doesn't actually properly model what is likely to happen on the road network anyway.
No, I understand that point. I wasn't trying to be too unkind as a general observation on modelling. I'm just recognising that it has its limitations and it will have margins for error. Indeed, we'll probably come to that when it comes to the questions of the road movements anticipated. We'll look at some of the tables that's been discussed earlier on, but we can no doubt come back to that point. But Mr. McCormick.
Yeah, thank you, sir. And it was just a minor point that I wanted to come back on, just in terms of something which Mr. MacLeod alluded to there. He made the comparison of an expensive piece of infrastructure in Winchborough over a large number of houses, and then went on to say a similarly large piece of infrastructure in Linlithgow over a smaller number of houses. And it was just for the absolute avoidance of doubt that the developer obligation at Winchborough has very, very significant obligations over and above the motorway junction, which won't apply in Linlithgow. So, for example, the developer there is obligated to build 3 primary schools from fully funded primary schools for 3,450 houses. They're obligated to build a marina, which they've done. They're obligated to fully remediate a landfill site, which is part of the development area, none of which applies in Linlithgow, clearly. So the simple comparison of an expensive piece of infrastructure, i.e. the motorway junction in Winchborough, with that in Linlithgow is, I would say respectfully, sir, an unfair comparison.
Okay, thank you.
Just, sir, to be absolutely clear, wasn't comparing the total level of developer contributions. What I was doing was comparing the approach of the council. So in the Winchborough scenario, as I understand it, the junction is necessitated by all of the houses, and all of the houses will contribute on a presumably equal basis. In this scenario, the junction is not necessitated by the houses alone. The houses alone contribute, I think, 15% of traffic from the evidence that the council has produced. And yet the council is asking the developers to pay for the entirety of the infrastructure. So it's not about the total quantum of contributions. It's the methodology, the approach, and compliance with the circular and so on that we will come to discuss later on.
So just very quickly in response, I mean, we set out in an earlier question from yourself that my view is that the approach in Winchborough is entirely consistent with the approach in Linlithgow. we reach a tipping point in the infrastructure, and the development has to pay for the interventions necessary after that. It's essentially done in, if you will, a roof tax basis, and that's generally the approach which applies in Winchborough. So the approach is the same from the council.
Thank you. I think to move on to question 2.5. Certainly, I'm scanning down on screen a fairly lengthy response by the council in this respect. So, starting with them, I was just going to ask whether there's anything further they wanted to say further to their answer that's been submitted in the hearing statement in relation to response to issue 2.5, and then go to Mr. MacLeod if he's got any questions arising from that. This is getting back into the central issue then of we've begun to talk about is the concept of the 100% contributions. This has been a theme that we've been beginning to develop discussion on in the course of this afternoon in particular. But Mr. Alexander, and any of your witnesses, first of all, whether you want to expand anything on the response to question 2.5.
Yeah, not from my point of view. As you say, it's a fairly robust and lengthy response, so I'm assuming hopefully everyone's had time to consider it, and we can get into 3 questions from yourself if that suits best.
Okay. Mr. MacLeod? Do you have any issues arising from the council's response?
A few. Some of which have been covered already. I mean, I suppose if we start with the first, leave aside the first paragraph perhaps, but if we look at the paragraph on the circular, paragraph 30, and the subsequent paragraph in relation to the LDP. Again, we've touched on this already, but the LDP does not make a linkage between the slip roads and the appeal site. What the LDP says is that in due course there will be a need for supplementary guidance that looks at what contributions will be needed, taking account of the principles in the circular. So before the council comes to apply or require contributions, there was an interim step that was expected by the LDP, and that was the publication and approval, no doubt, of the supplementary guidance, and that has not happened. Again, the council in the 3rd paragraph, they say that INF 1 sets out that infrastructure requirements are identified in Appendix 2. Again, they're not for this site. Further details will be provided in the supplementary guidance and the action programme. But the council's quote there is not complete, because the policy then goes on to say any related planning obligations will require to meet the policy and legal tests set out above. And as I said earlier on, that's the circular and the LSIP case.
Yeah.
The action programme, and again alluded to this earlier, the action programme is not a policy document. The action programme explains how policies and proposals in the LDP are expected to be taken forward. And I've had a look at the action programme. I'm afraid I don't actually have a page reference for it, but I can get that for you. But there is a section on Linlithgow and Linlithgow Bridge. And in that, there are various columns. There's one which is headed infrastructure requirements. It's not very easy to use because it's a very long table, so you need to go back to see what the heading is. But the relevant column for infrastructure requirements has M9 Junction 3 westbound slips at Boroughmuir. Responsibility is WLC, so the council is supposedly responsible for delivering it. Although we've got a point to seek some clarity on in just a moment. There is then a requirement for supplementary guidance to be prepared on developer obligations for transport infrastructure. And that again is the council, fairly obviously. And then it says developer obligations towards transportation infrastructure, and the responsibility there is the developer. Now again, just kind of taking that sequence of events, you have an expectation that the council is going to deliver the slip roads. That's what the LDP says. The council intends to deliver the slip roads, and there's a policy, more or less to that effect. There's a policy that safeguards the land for the slips. I don't know that there is actually one that says they will deliver them, but that seems to be the intention. In order to fund those, the council is required by policy INF1 to produce supplementary guidance. And that supplementary guidance has parameters, those being Scottish Government policy on developer contributions and the Supreme Court's judgment in ELSIC. And the council has failed to get its supplementary guidance through on that basis. And yet, and we'll come back to this issue, the council wants the appellants in this case to pay exactly the same contribution that the supplementary guidance that was knocked back by Scottish Government says should be paid. So our position on this, and one point on the supplementary guidance, I'll then maybe stop and let the council come back. But our position on this is the way the LDP is drafted, it envisaged the possibility of developments contributing something towards slip roads. That I think is what the LDP should actually be taken as saying, possibility. But in order for that possibility to become a reality, there was a need for further guidance to be produced that went through the various tests set out in the circular and by the Supreme Court, and the council has not managed to achieve that. And as indicated, the evidence shows that there is not a need for what the council's proposing. And one final point is just related to who is responsible for delivering the slips, because the action programme is inconsistent. And the page that I referred to suggests that the council will be responsible, and Mr. Snell tells me that's page 152 of the action programme. So that page says that the council is responsible, but page 35 says, specifically in relation to the slips themselves, responsibility / involvement / finance, Transport Scotland and developers in West Lothian and Falkirk Council area. And there is a bit of doubt in our mind about this because as we were talking about earlier on, part of the westbound slips are within Falkirk Council's area. So West Lothian Council has no ability to deliver that. And yet, I think the total junction cost that they are asking the developers to contribute to them relates to infrastructure that's not in their area. So really, are the council delivering that and how? Or are Transport Scotland delivering it? And what is their position on all of this? So I'm sorry, there's quite a lot in all of that. I appreciate.
Okay. I don't know if Mr. Alexander, you want to come back in, or Mr. McCorriston, or anyone else, in particular on that last factual issue as the part of the area falling out with West Lothian's council area.
Thanks, sir. I mean, I suspect Craig might know more of the backgrounds. an eye, but I suppose it falls quite neatly into the point we discussed earlier, where land costs are excluded. Now, I appreciate there will need to be a mechanism for delivery, but that is a question that is there, whether it's this authority along with an adjoining authority's assistance, or indeed a central government agency that exercises those powers if the land can't be acquired through agreement. So that is a point there, I suppose, that has no impact on the developer as I see it. It's a route to delivering the infrastructure that the council will formulate a strategy for. But I see Craig has lifted his hand.
Yeah. I'll bring in Mr. McCorson just now. I see that Mr. McLeod's got his hand up again, but that may be sort of bring in the council's position collectively, then come back to you.
Yeah, thank you, sir. I wonder if there is an attempt to identify a problem which isn't there. I accept it's unhelpful that there's different references in the action plan, but you know this is a very large document, and it's you know, inevitable, I guess, that that there will be some inconsistencies there. But the process is absolutely clear. So Transport Scotland, it is part of the trunk road network. It's a motorway network, so the ultimate responsibility for delivery would be Transport Scotland. It's their infrastructure. There was discussions, as we identified earlier on, the motorway junction has been identified in successive local development plans, and there has been discussion with Transport Scotland in relation to that, and Transport Scotland have raised no objection to the inclusion of the motorway junction in the local development plan. Mr. MacLeod is absolutely right that there is a slip road which is in Falkirk Council's area. There is a minute of agreement essentially between West Lothian Council and Falkirk Council in, I use the term minute of agreement broadly, that there is no legally no legal document that obligates either party to do that. But the West Lothian Council and Falkirk Council worked together to submit a levelling up fund bid application for the motorway junction. That was a joint application by both organisations, and it set out that application, which was unfortunately unsuccessful, but that application set out the process for procurement of all aspects of delivery of the motorway junction. So if there's a suggestion that there's a difficulty in getting agreement with Falkirk Council to do this, that is not the case. We have already worked on a delivery plan for the interventions that are necessary. Thank you, sir.
Presumably the cost, whatever the minute of agreement comes to, the cost will be borne ultimately by West Lothian Council. And the 8 point whatever million that's been cited in documentation here would be borne by West Lothian, and it's therefore on that basis that developer contribution to the extent required is imposed. Because obviously if Falkirk Council were bearing some of the cost of building the road, that certainly I think would probably complicate the issue as to the ability of West Lothian to recover developer contributions that are paid for by a different council. That's putting Mr. MacLeod's question a different way. Presumably the ultimate cost of this would come out of either West Lothian's budgets financed through developer contributions, or to the extent that's not required, Transport Scotland perhaps, and that may involve a repayment to the developers in this case. Presumably it's not the case that an obligation is being imposed involving West Lothian's expenditure beyond its council area that it's not responsible for. You see what I mean?
I do, sir, and that's not the case. I mean, if Transport Scotland come along and offer up the money, then jobs are good, and we can all pack up today and go home. But the reality is that that's not going to happen. We have sought that those contributions, and it's clear that the the National Transport Agency is not going to fund that project, which requires the intervention of the council. But the funding would be wholly from the council. So West Lothian Council would be responsible for the project, albeit that part of that expenditure was outside the West Lothian Council area. I don't believe that causes any procedural difficulties, clearly, as long as we've got control of the land and the consent of the planning authority, because it would require planning consent for the slip roads over there.
Mr. McLeod?
I'm going to reserve my position to come back on what Section 75 of the Act actually says on that issue. I don't want to take time just now digging that out and making submissions on the hoof. But in essence, just to clarify, Mr. McCorrison is saying that the West Lothian planning applications will be paying for Falkirk road infrastructure. That's West Lothian's position. Is that correct?
It will pay for a motorway junction, which is partly within the partly within the Falkirk Council area.
Yeah. And I just had one other question through you, sir, for Mr. McCorrison, if I may. Mr. McCorrison mentioned that there had been discussion with Transport Scotland and the ultimate responsibility for delivery is with Transport Scotland. I'd quite like to understand when the last discussion with Transport Scotland was and what their position on delivery of this motorway junction in the form proposed by the council is.
Steve Lovell might be able to say whether there was any consultation with them in terms of the supplementary guidance, but the last substantive engagement will have been through the LDP process and prior to the adoption of the local development plan, which includes the slips. So there would have been a statutory consultee as part of that process.
Okay, so no substantive discussion with Transport Scotland on delivery of the slips since 2018 or 2017?
I think Mr. Lovell's maybe able to come in with a comment on that, but we'll hold that question.
No, it was just to confirm that Transport Scotland were a consultee when the SG was being prepared a couple of years back. As far as I'm aware, there has been no further discussions with them about that.
Okay, so Mr. McLeod's point about timings then of the 2018, I think, is relevant to that. My understanding is that there's nothing to prohibit councils acquiring land out with their own area, but that's simply my understanding of the position. And I've noted that Mr. McLeod has reserved his position on the implications of that. I too would like to think through what the implications of that would be for the purposes of the current appeal. Okay. We've been dancing around the subject of the Scottish Government direction on the supplementary guidance and the then Chief Planner's email of 19th July 2021 and the issues arising from that. I mean, I think I understand the issue put by the appellant, and I understand as well the position of the council. But starting with Mr. McLeod, is there anything you want to say further to what's been said already in relation to the direction? I've seen the direction, I've seen the email, and I've seen the explanation from the council under reference to the then Chief Planner's like qualification of his email there. But it'd be useful just to get a kind of brief summary as to what the appellant's position is in relation to the status of the supplementary guidance and the extent to which it can or cannot be relied on as an indication of the policy background not in relation, I think, to scale and kind, because that's where the direction, at least in part, was very clear, that the approval was not being given because of the issue of scale and kind. But there's a question in my mind as whether that necessarily, the supplementary guidance cannot be adopted, whether the direction necessarily means that no part of the supplementary guidance can be had regard to. I just want to be completely clear in the appellant's position in that respect.
I suppose the way that I would put it, sir, is that the Scottish Government refused to allow the Council to approve its supplementary guidance because the evidence did not justify the contributions that were being sought. So that's the kind of the general headline point, as I would put it. What the Council says is, yes, but Scottish Government told us after they did that that we could still require developer contributions on a case-by-case basis. So we're okay to request this contribution. Now, this contribution is based entirely on the evidence that Scottish Government was unhappy with. And I have to say, sir, I think the Council's position on this is irrational. Cannot see how it can possibly rely on evidence that Scottish Government has told it is not adequate to allow adoption in compliance with the circular.
Okay, I don't know if Mr. Coruscant or Mr. Alexander wants to come back on this point.
Yeah, thank you, sir. I suppose I talked about this a little earlier on, and I suppose just to be clear, what the Council are doing in terms of the determination of the application, in terms of the committee report, and now their position in terms of this appeal are looking to the LDP and the action programme and the sister report. So they're not seeking to rely on the SG itself. It's those three elements that they're looking to. The committee report itself, which is one of the appellant documents, A12, just sets it out neatly at paragraph 411 and how the Council determined this application. We've talked about this a lot, but clearly there is an issue with the High Street that needs to be resolved. And this is the Council's proposal on how to resolve it with the introduction of 9 new sites to the LDP. And I think I'll leave it there for now.
Mr. Coruscant.
Thank you again, sir. So I think there's a couple of points to make here. I made some of them earlier, but I will repeat those just for clarity. So, you know, this was all happening at the time that the application was before the Council. There was extensive correspondence with the appellants at that time, setting out that this created a problem with supporting the application at Deanburn. I appreciate that CALA themselves are not part of this part of the discussion and that the appeal is by the landowner. But I set out earlier on the circumstances which arose where we sought to overcome the difficulty by reaching agreement with CALA. That resulted in CALA submitting a letter to the Council saying they considered that the obligations were justified, that they would seek to persuade the landowner of the same, and on that basis, would they mind awfully if would the Council mind awfully just granting planning consent for them? Well, we did. With hindsight, was that the right thing to do? Well, who knows? But certainly, if we knew where we are now at the time, planning permission, I doubt, would have been granted. Just in relation to the wording of the direction itself, I mean, what I take from the direction is that the ministers were concerned about some of the use of the junction being from developments in Bowness, Falkirk Council area, and that they weren't contributing. That's an understandable concern if the focus was solely on the motorway junction. But as we have said on a number of occasions, we'll keep saying that the focus is on the use of the high street, not the junction itself. So what the minister's letter goes on to say is that on this basis, it has not, brackets, on the evidence presented, been demonstrated that there is sufficient justification for seeking the full estimated cost. So on the evidence presented at that point in time, it was that evidence that we then engaged with the chief planner on about changing that evidence. And it still remains open to the council to present that supplementary guidance on a different evidential base. But we had a discussion with the chief planner, and the chief planner on the back of those discussions said, well, of course, it's okay for you to seek seek contributions where you think they are justified. So while I accept totally the position with the supplementary guidance, I don't accept it's quite as clear as the supplementary guidance has been rejected and the position with respect to contributions is now dead in the water. I think that there is the opportunity to present additional evidence or present the evidence in a different way and to address specifically the matter in relation to contributions from Falkirk. Thank you, sir.
A couple of questions from my perspective. I didn't really read the Falkirk thing as being the main issue, to be honest. I mean, it certainly mentions that. One sense, I didn't fully understand the concern in relation to the Falkirk area, but it's certainly there in the direction. I suppose my two questions are, this is now some time ago since that exchange took place, and without delving too much into what you might regard as confidential discussions with the new or not so new chief planner who's now in place, is there anything you can appropriately say in relation to where you've got with PARD, Planning Appeals and Regeneration Division, in seeking to address these issues in such a way that could allow the supplementary guidance to be adopted? And the related question, I suppose, is now the NPF4 is in place and the Section 22 is repealed, I think from February this year when NPF4 came into play, is the issue of statutory supplementary guidance, is that now in any event dead in the water? So is this a question of Scottish Government approval? Does this really matter anymore?
Yeah, I think, sir, you sum up the difficulty for the council quite well there. That the world continues to move on. We entered into significant discussions with the chief planner, which resulted in the letter which we obtained. Without going into confidentialities, and in any case, they're not matters before you in this hearing, but there was discussions about the whole approach to developer obligations being reviewed, and that would resolve all the problems for the council in delivery of infrastructure. I mean, what NPF4, insofar as it's of relevance here, reiterates the infrastructure first approach to supporting development. We have to have the infrastructure that is necessary to support development. There's going to be a new approach to developer obligations, whether that's a tariff-based approach or something different. It would be helpful from the council's perspective if that all moved on a whole lot quicker than it has. It hasn't. We've got to make the best of that, and the chief planner has told us to, with the greatest of respect and apologies for the loose language, crack on and seek contributions where we think they are justified. we think they're justified, and that's what we've done.
Okay, thank you. Two slight minor questions for the. You mentioned MPF4, and I think in your hearing statement you referenced policy 14. I think from other papers it suggested the infrastructure first is policy 18. I think policy 14 of NPF4 is about placemaking, so I assume the references, I think in 2.5 and 2.16 should be NPF policy 18 rather than 14. My other question, I suppose, to do with the transition to the new arrangements after the 2019 Act, is that if there was a reference, and I think some of the papers originally involved, and this was right at the time because it was 18 months ago, reference to SDP policies, and I kind of wonder, Mr. McCorson, whether now that the Planning Act changes have taken effect, whether there's any continued relevance to those policies, or whether it's INF1, MPF4, whatever the right policy might happen to be, and the SDP policies are now effectively sort of redundant for these purposes, or is that not right?
Well, sir, you'll be aware that there's a forthcoming legal case which will set out the status of SDP NPF policies. I mean, the courts will decide ultimately. My view and the council's view is that upon adoption of NPF4, 13th of February or whenever it was, that the strategic development plan ceased to be part of the development plan, and the policies of that document no longer had relevance. I think we've got a slightly complicated situation here where the planning permission which we're dealing with, I think, was dealt it would have been dealt with under the old arrangements before the adoption of NPF4. We're dealing with the obligation appeal under a different set of arrangements, far from ideal, but from a planning perspective, so that's for the solicitors to sort out, I guess.
Mr. Alexander may say something. I mean, it may well be we've got enough information in terms of the policy background, either relevant to be addressed or not, as the case may be, to deal with this particular appeal without going into that difficult water. But Mr. Alexander, first of all, then Mr. MacLeod, by way of general response.
Yeah, thank you, sir. I think, as you say, for the purpose of a planning obligation appeal, I don't think we're in that territory to be short on the point. We are obviously looking at the legal and circular tests for this particular planning obligation has been challenged, and that's what we are concerned with. We also have emerging policies through MPF4 with infrastructure first, and it also that approach obviously dovetails with the policy that we're looking at in our local development plan. In any event, I would say it's a similar policy.
And Mr. MacLeod, am I looking for a complication too many here, am I?
I've never said that, sir, but I think in this case we have, as Mr. Alexander and Mr. McCorson have said, we have a new national policy which is 18, and helpfully policy 18 bakes in the circular in the same way as policy INF1 does. So I think the issues remain the same. There are perhaps just a couple of short points to come back on in relation to the direction letter and the council's approach subsequent to that. And we don't know the full context of the discussions that took place with the Chief Planner, but Mr. Snedden was quite rightly making the point to me that there was a direction that was given to the council that it shouldn't adopt its supplementary guidance on transport contributions or development contributions towards transport infrastructure. That applied council-wide. So Mr. McNerney's comments about the local authority being able to proceed on a case-by-case basis where they thought that was justified was a perfectly legitimate comment to make in the context of West Lothian as a whole. The fundamental point, which I've alluded to earlier on, is that the Scottish ministers were not happy with the evidence specific to Linlithgow. Now, the council continues to rely on that evidence as the basis for the contributions. And Mr. Alexander says the council relies on, I think I have him noted as saying, the LDP policy, the action programme, and the sister report. None of those documents sets out what the developer contribution should be. The only place that the per unit contribution is set out is the draft supplementary guidance that the Scottish Government has said is no good. So the council can claim that it only relies on certain documents and not others, but it's patently clear that the council continues to rely on the draft supplementary guidance and the methodology that is set out there. And one final point, and this is in written submissions already. When the council received comments on the draft supplementary guidance, one of them was along the lines of what we're talking about now, but whether it was appropriate to divvy up the total cost of the slip roads by reference to the housing units. And in this is the supporting statement to the application to modify that we submitted. So paragraphs 6.21 and 6.22 of that supporting statement says, in the council's summary of consultation response on the SG, it states, developer contributions are required to pay for infrastructure improvements where it is shown that the development causes an overcapacity issue. For road traffic effects, this equates to the increase in the number of trips. However, the easier way to work out the same contribution is where all developments have an impact. The total cost of the infrastructure improvement is divided by the new number of housing units, giving a roof rate. Now, Mr. McCorson's alluded to this in his response, and he talked about the roof tax and how confidential discussions with the chief planner had indicated that once the new system, possible new system is in place, the council's problems would go away. That may be correct. In other words, we may have an infrastructure levy that does just apply contributions on a roof tax. We do not have that situation now. That is not what Scottish Government policy is, and it is not what the law allows for. And that is at the heart of this issue. And that's probably about all I need to say on the issue at the moment.
Yeah, I'll go back to Mr. McCorson on that.
Yeah, thank you, sir. And I suspect you don't want to get into a back and forth on this. Neither do I. But there was just one point that I wanted to pick up, and I may have misunderstood what Mr. MacLeod said there in terms of the direction, and that did I pick up correctly that the direction applied to the whole of West Lothian? If that was a suggestion, then that is incorrect. That is not the case. The appendix to the direction sets out the changes which are required under to the A801 contribution and the Linlithgow contribution. So those were the only. There's some other stuff in there about legal expenses, etc., which apply generally, but the two specific requirements which were removed were the 801 contributions and Linlithgow contributions. Just in terms of those confidential discussions with the chief planner, which resulted in the chief planner's letter to me, I can reassure Mr. MacLeod that those discussions were specifically in relation to Linlithgow. The council ultimately did not have an issue with the direction in relation to the A801 contributions, but it did have an issue in relation to Linlithgow. So I can be reassured that the chief planner's response to myself, while it will apply generally, was written specifically in the context of contributions in Linlithgow. Thank you, sir.
And my understanding is that the supplementary guidance, as approved by the council, at least for adoption, and it went to committee twice, the 23rd of June and the 17th of November 2020. My understanding from reading the papers is that the adoption on 17th November 2020 arose because of modifications that were made in relation to the A801. But my understanding, the A801 only. That was my reading of the difference between the draft as originally presented in the June and the draft that was adopted from the council's perspective, at least in the November.
Yes, so the committee report in June was the SG was approved at that committee. Subsequent to that, and before we were able to report it to Scottish Government, we received the appeal decision on the Armadale proposals. And that made us reconsider the content of the guidance, and it was remitted back to committee in November.
Okay, and that was the 801 appeal that's been referenced by the appellants in this appeal. Yes, that was my understanding, so that's very helpful. Thank you. Mr. Alexander?
Thank you, sir. Just a couple of points, if you'll indulge me. It just goes back to my previous statement, what the council are relying on here. And as mentioned, the LDP action report and the sister report, action programme rather than the sister report. What you find in the sister report is it's clear on the values that we're talking about. Page 12 outlines that's 8.5 million for the western facing slips. Then we also have on page 17 and page 18 the values of 330,000 and 143, which takes us to the 473,000 for the town centre. So my point is, and the LDP obviously shows that we have 9 allocated sites that we need a solution to the high street for. We also know the practical reality of the development management processes that 3 sites have obtained consent already. So that's how we get to the figure, which obviously is in the committee report of the 15,938 per unit, by simply dividing the unit number 563 by that overall total.
Thank you. Mr. McLeod, your hand up.
Sorry, sir, yes. Yeah, I don't think I need to say anything more in response to what Mr. Alexander said. I don't think we're not saying anything contradictory to one another. The sister report itself doesn't set out the policy basis on which contributions will be determined. He says that it provides the evidence that allowed the council to reach its decision. That is what it is. Just on the
supplementary guidance. So I mean, subject to your point about the SG generally, it is a document that's attached as an annex to it. So
on the direction letter itself and the status of the supplementary guidance, I think Mr. McCorson and I may have been talking at slight cross purposes. I think what he's said has probably clarified things anyway. But just to be clear, my understanding is that although Scottish Government had particular issues with the A801, with the M9 slip roads and a couple of other bits that we're not really concerned with, they said to the council, you cannot adopt this supplementary guidance until such time as you modify the SG in this way. And I don't think the council has adopted the supplementary guidance yet. Is that correct?
That's correct.
Yeah, someone's chipping in. That's good. That's certainly my understanding as well. While the A801 issues were addressed, the council and the Scottish Government don't agree on the issues in relation to the slips, and they haven't reached agreement. And so my understanding is the SG has not been adopted by the council. I think someone chipped in a yes to that.
I don't think I need to say any more at this stage.
Okay, thank you. I'm conscious though after 4 o'clock that there's quite meaty issues still that we need to be addressing, even in relation to the west-facing slips. I'm inclined to close today's hearing session at this stage. I'm probably inclined to meet at 10 tomorrow morning. I don't think we need an earlier start, unless anybody thinks things differently. While, as I say, there's some meaty topics left still on western facing slips. We have touched upon some of the air quality issues, and I'd be hopeful that if we convene tomorrow at 10, I'd be reasonably confident that we could complete the hearing session at least in the course of tomorrow. But others may take a different view as to a start point.
10 o'clock's fine by me, sir. I think we've made pretty good progress today.
Alexander?
Yeah, agreed. 10 a.m. That suits us well. Thank you.
Right, that's fine. In that case, I shall let you all away, and thank you to Dr. Kelly as well for his patience in listening to a range of issues of direct and in some case perhaps indirect interest to him. But he's very welcome to join us again tomorrow. So we'll reconvene at 10 a.m. in the morning. Thank you.